So who am I? I'm Dustin Chaniker. I'm one of the partners at Fowler St. Clair's. My 6th year of practice. And like Sean said, I handle all the firm's probate, as well as the estate planning aspect of our firm. And what I like to do then is also teach these classes where I can educate people on kind of the intersection of probate and real estate. So I also teach, in addition to these classes for AAIP, I teach continuing education for real estate agents to get them their education units and educate them on probate in the real estate world. So I hope this class is useful to you. We'll kind of jump right in. What is probate? For a lot of you, you've probably maybe have never heard the word probate, but Black's Law Dictionary, which is essentially the holy grail of an attorney, it defines it as the judicial procedure by which a testamentary document is established to be a valid will, the proving of a will to the satisfaction of the court. So in layman's terms, it's basically when somebody dies, probate is the process we go through to either tell the court there is or is not a will, and then now we follow the terms of either the will or what Arizona law dictates happens to the assets. And that process is called probate. Overview of the class. Let me pause here. I taught this class more or less last year at AAIP. I think it was in April. And so I don't know how many repeat attendees we have that were here last year that heard this. But last year, my presentation got kind of squished because I was the last one to present. So we were flying through a lot of it. So what I did is last year we focused more on the probate side of what are all the different types. These are the different procedures, requirements, forms, all that stuff. This year, I want to be able to not have a ton of overlap. So we're going to do a brief overview of that, and then I want to move forward to how do we avoid this probate process, if at all possible. And so hopefully that can bring some value to you, learning a little bit about the probate, but then more importantly, the problems associated with probate, and then ultimately, how do we protect assets of our clients by avoiding probate. Like I said, the title of this is I See Dead People. So not only are there going to be a lot of movie and TV references, but the idea is that when people die, something has to happen to their assets. And so going through probate or proper planning is going to help us avoid having what I like to call ghost owners on real estate, where they've died, but they still own their real estate. Okay, so let's jump into the probate side. 7 different types of probate. Informal probate, formal probate, tardy, subsequently discovered property, ancillary probate, affidavit of succession to real property, and affidavit of collection of personal property. Those are the 7 different kind of types, and they all have different requirements that we'll go through, and different contexts where they apply. Some of them are pretty similar, and some of them are very different. There's a broad spectrum of what's required for each of those. So let's start with informal probate. Who needs a real judge? So we have informal probate is essentially the kind of default position that we go to, where when somebody dies, you assume that it's going to be an informal probate unless we end up finding that it doesn't meet those requirements, or we can tack it under a different, more simplified view. So if there's a will, it's considered a testate probate. If there's no will, it's intestate. The court in Arizona has created a probate registrar. They're not a judge. It's basically the head clerk that deals with probate matters. And the benefit of an informal probate is we don't have to have a hearing, because if we can check all of the boxes, then the probate registrar can review and approve these applications for probate. So it simplifies the process. It makes it shorter. We're not bound by the judge's schedule of having to get a hearing on the calendar. So it's a lot easier to get something done. Excuse me. The process we have to go through. Somebody needs to be appointed as, in Arizona we call it the personal representative. Other states call it executor, administrator, but in Arizona, it's the personal representative. ARS 143203 discusses the priority of who can be appointed as that personal representative. I can't just go be appointed for some random person. You have to have some connection to that person who died. And so the very first, I'll let you read through this. I've kind of bolded the parts that are important, but essentially it goes, if there's a will, in a will, you always identify who the personal representative is going to be. They have first priority because we want to honor the intent and the wishes of the person who died. What better way to do that than follow what they put in their will? From there, if all of those people have died, then it goes to the surviving spouse if they're going to be receiving assets. If that person's not alive, then it goes to other people under the will. If there is no will, then surviving spouse has priority. Then other heirs as defined by Arizona law, which is going to be children, grandchildren, parents, siblings. Then we get down into some of these kind of other catch-all categories as we have the VA. If it's 45 days after death, then it can be a creditor. And then finally, the public fiduciary if there's nobody else. And so the thing that's important here is when we're doing an informal probate, the person who is filing that probate needs to be the person with priority. So let's use an example. If there is a will that says person A is to be appointed as personal representative, but maybe they live in a different state and person B is the alternate under the will. Well, person A has priority, but person B maybe is the one coming to you to help them with the probate. So what needs to happen in that scenario is either person A needs to be the one that brings the probate, or person A can sign a waiver of right to appointment that then skips over them essentially. And so it allows the person B, who's the one that's come to you, to now be able to go and probate that will. And so it's important to make sure you're dealing with the right person. Somebody might come to you saying, hey, we need to probate this. And then you have to get creative to figure out how you can get them appointed if they don't have priority. Anyone above them in this list has priority above them, so they need to sign a waiver. And then anybody in the same category also has to sign a waiver in order for one of them to do it. So the classic example of that is there's 3 siblings and one of them comes to you to do the probate. Well, they all have equal right to appointment as heirs of the decedent. Let's assume that everybody else above them doesn't exist. Well, now 3 of them, they can either all 3 sign the probate documents, or 2 of them can sign a waiver. One of
Is
them
now joining.
can then now bring the probate on their own. So it takes some cooperation. You run into problems if there's not cooperation. If any of you have dealt with probate, you are probably just as aware as I am that when somebody passes away, it's not a time of happiness, obviously, but there's often animosity and conflict that comes out. Unfortunately, people are wanting the money, people are hurt, past wrongs start coming up, and all these things. So it's few and far between when people are all on the same page and willing to cooperate. So that's kind of how the importance of this statute and the right to appointment comes into play. So let's look at the requirements of an informal probate. The decedent had to have lived in Arizona or owned property here, and it's county specific. So you have to file in the county where they lived or owned property. If there's a will, we have to have the original of the will. And we have to put information about any prior personal representatives. This part's important for an informal probate. It has to be within 2 years from the date of the decedent's death. If we start getting outside of that 2 years, now we've got a whole other category, which we'll talk about later, which is the tardy probate. So if you're close to that, make sure you get it filed before the 2 years. If you're wanting to do an informal probate, which we'll talk about later, like I said, there might be a benefit of waiting till the 2 years has passed and doing a tardy probate. It just depends on the scenario. You have to be an interested party, which is basically, family, person entitled to receive assets, something like that. Okay, process. We're going to kind of go through this quickly, but essentially the court requires anyone, whether they're using an attorney, a document preparer, the court requires that the personal representative complete an online training that the court has put together, kind of overviewing this whole process for them. If you haven't watched that and you're interested in getting into this probate world, it's actually probably very helpful for you, because now you know this is what your client's going to be going through, and their duties, their requirements. It kind of goes over all of that stuff briefly, but I think it's 20 minutes or so of video that you watch. And that's the other thing. Don and I were talking about this the other day. Of probate is a very form-driven process. For a lot of these categories, you'll see there's similarities, but they're very form-driven. And so if it's not something you have started dabbling in, you should go check it out. The court, Maricopa County has on their self-service forms, they have all of the informal probate forms and some of the other ones as well. And so it might be worth going and looking. I've created all of my own forms and can generate it from our software. But it is something that is very easy to pick up. There's instruction packets, there's forms. So if it's something that interests you, you should definitely go check it out. I enjoy it, and it's pretty interesting and pretty simple at the same time.
Hey, Dustin, I'm
Yeah.
gonna jump in here. I'll let other folks who are in the conference room and stuff do this as well. But we got a couple of questions that came in. One from Kim DeMarco says, "Is there a way to register a will with the courts prior to death? So it's on file with the courts, or do you have to rely on the person or the family after death to register that will?"
Yeah, I think that's an older practice of recording a trust or a will. I don't know that they recorded wills. I have never seen this in my practice, and I don't practice it on my estate planning side where we do something prior. I guess I'm not going to say no, you can't do that, but I don't know of a way off the top of my head and in my experience where you can do something prior to your death to give the court your will. I don't think they want to hold that type of thing, and take that responsibility of now this is the original will, and what happens if you amend it afterwards but don't file that. I'm going to say that they probably don't accept something like that, and so.
Is it possible? Is it possible? Maybe I could envision a scenario where someone who creates a will anticipates potential conflict and wants to make sure that there's a secure version of their final wishes somewhere that's not going to be tampered with. If not with the court, what would you suggest?
Safe deposit box. That's usually the place, or a safe. I know that's not anything formal with the court, but that's usually the location that I tell people to put your important documents, like a will or a trust. But like I said, I don't know that you can just go and file it, and I wouldn't suggest recording it, unless you want all of that information public record. But that's I just tell you, you can probably find, maybe like a statutory agent company that would be willing to hold documents like that, public fiduciary, or excuse me, private fiduciaries maybe. But again, the cost of that's probably a bit prohibitive. I'm seeing a question on residency requirements. Typically, we look at, where's your home state, which is going to be where are you the majority of the year, more than half of the months. And so, it doesn't define it as domiciled. It just says owned or lived here. But I would go where are the bulk of the assets? Are they going to be, in Washington State, or are they going to be in Arizona? And that's probably going to be your location where you file. Let's go on through the kind of filing process. So you have your client do the training, and then you're going to prepare the application for probate, with or without a will. And then like I said earlier, if there's somebody with an equal or prior right to appointment, then you're going to have to obtain their waivers, or else have all of them signed. You file that initial packet. and it usually takes in Maricopa County. We'll show the difference here. Maricopa County, sometimes it's as quick as the same day that it's processed and approved. Most I've had to wait in Maricopa County is 2 or 3 days. Pinal County, which is where I live in Casa Grande, I've waited over a month for them to process and approve simple informal probate documents. So it just depends on the county where you are. If there's an emergency and you're in one of these smaller counties, I usually file more of something that says emergency filing. Sometimes they'll take it, or you just call them and bug them until they get annoyed with you and process it. But once that's done, the court will issue letters of appointment, and that's the golden ticket that everybody needs and everybody's waiting for. That now shows everyone that the personal representative has the power to act on behalf of the estate. And so if you're selling real estate, that's what the title company will need. If you're trying to get access to a bank account, that's what they'll need. And so the court will issue those letters, and that's the important thing that we're looking for. And like I said, at that point, you can now close on property and have access. The next step then in an informal probate is we have to give notices. We send notice to all of the parties that are interested, which is going to be, family members, people under the will who are entitled to assets, telling them that you've been appointed, your client's been appointed, and that they are now acting on behalf of the estate. We have to mail notice to creditors, to all creditors that we know of. Now, again, that doesn't mean we can just bury our heads and say, no, we don't know of anybody. I always tell my clients, go through the mail, put together a list of all of the bills, utilities, anything like that you're getting in the mail on behalf of the estate, and put that into the table for me, and that's who we send notice to as actual creditors. For the creditors we don't know about, we have to publish a notice to creditors for 3 consecutive weeks in the county where the filing was made. That first publication date starts a 4-month clock that it covers all of these creditors. Essentially, at that point, the creditors have 4 months to make their claim, to have their claim allowed. If they fail to make that claim, then it's barred forever and the estate's not obligated to pay it. We have to file proof of notice that we've sent these notices and published with the court. I'm gonna finish the informal probate, and then I'll jump to some questions because I've seen them pop up. Next up, we prepare an inventory. We don't have to itemize everything. It's kind of more estimated values and categories of assets. You can either file that with the court, or you can mail it to all of the interested parties, and you don't file it. And we have to wait. We have to wait for that 4 months to pass, and then at that point, now you can distribute and pay all of the expenses. This slide, I'm not going to go through it in detail. It identifies the order in which things get paid, which first and foremost is administrative expenses, including attorney's fees, court costs, administrative reimbursements, compensation, all that stuff. It's important when we're dealing with smaller estates because it means your client has the first crack at any funds there are to pay their expenses and actually make this worth it for them. And then we pay creditors, and anything left gets distributed. Finally, then we can, once all the assets have been distributed, you do a final accounting and send that to the interested parties, and then you file a closing statement with the court. That wraps up informal probate in a very brief nutshell. This is how you can identify informal probate. It's just your default choice. It's kind of the starting point of where we go. So I'm going to field some of these questions as best as I can without getting bogged down. Safety deposit boxes. It kind of just depends. You can record it with the county recorder, the will, going back to that question. You can record it with you can record anything. It's just a matter of if your client wants that to be public record. The probate court, Pima County, they do not file wills for safekeeping. Again, yeah, you can record it, but that makes it public record. So getting recorded in Cochise. Okay, so apparently practice in Cochise is to still record them. And then, yeah, I think that's just the bottom line is you tell your client, look, you can go record this, and then at any point when probate needs to happen, we have an official record. You can go get a certified copy of it and file that with the court for the probate. But your clients need to know that that's public record and that anybody can now view that. And so that's the trade-off there. The alternative is put it in a place that's safe, and then you can now tell your personal representative. And I think that's the bottom line. The personal representative is the person your client trusts to go and do the probate for them. And so at that point, hopefully they trust them enough to not tamper with the document or anything like that. So you tell them where the document is kept and trust that they're not going to go and do something nefarious. But what qualifies as a claim? When we're talking about sending notice to actual creditors, a bill, an invoice, that's enough to notify you that there are creditors out there, and that they need to be sent actual notice. If there is somebody who, that when it comes to the actual finding of creditors that made their claims in the 4 months, the way that I take the approach is a bill to the person is not going to be a claim. I'm sure there's going to be litigation on that and case law that's going to define specifically what is and isn't when it comes to that, but it's going to be fact specific. And so the process I do there is if they've sent a bill but haven't actually filed a notice of claim or sent the bill to me, because part of the notice that you send is if you have a claim, mail it to, and I put my address on behalf of the personal representative. And so if they just send a bill to the decedent's house, that doesn't mean that they know that they've died. That doesn't mean that they're making a claim. It just means that's part of their regular practice of invoicing, right? And so to me, the claim needs to be sent to me or filed with the court. Now that's to me an allowed claim. So the procedure I get with bills is I send a notice of disallowance of claim to them, and it basically says we're treating your bill not as a claim, and so therefore you are not going to be included in the payout to creditors. They then have 60 days to contest that, and they say, no, we meant to send that as a claim. We properly made our claim. And then at that point, you can litigate it, argue it, or just pay it. So that's how we handle creditor claims. Let's jump now to the next category, which is formal probate, where suits are required. This is the one where now it's either going to be your clients representing themselves or the ones that you send over to us and we take care of for you. There's several different ways these come about. And so let's look at some of these. Maybe there's a petitioner who doesn't have the highest priority for appointment and they can't get the necessary waivers from everybody else. And so they can't file an informal probate. So their only option is now formal probate. This is kind of the end of the spectrum of complexity, cost, time, because formal probate is much more involved. It can also come up, there's a challenge to the validity of a will. I've had one where filed the will with an informal probate, and then somebody filed an objection to it, which is going to be these kind of last few categories here. Somebody then files a responsive pleading to an informal probate. That pulls it out of informal probate and now into the formal probate context. So they can challenge if the will was valid or if it was made under duress or by a vulnerable adult, the deathbed kind of category of wills. Or maybe there's an objection that the person filing shouldn't be appointed. If we have a ex-felon who was in prison for theft, embezzlement, all this stuff, they're probably not going to be the best person to be appointed as personal representative. They might have highest priority, but they're probably not the best person for it. So another person can file an objection and tell the court, look, they're not fit to serve, appoint either me or whatever the context might be, appoint the alternate personal representative. Then the last category is we can't find the original will. Informal probates require the original will. So if you can't find it, kind of the context we're talking about here, where we can record it to protect against this. If you can't find it, now you have to go to the court with a copy and say, look, we have this photocopy, can't find the original, but there's no reason to believe that this copy has been tampered with. But all of these things require a hearing so that the judge can now be the one who assesses the factual validity of these things, and then they decide ultimately on how these play out.
Dustin, there's a couple questions I see. Do you see
Yeah.
them?
Yeah. Let's see. Dollar amount. No, there's no dollar amount. You could have a $10 billion estate go through informal probate if you wanted. It's going to be complex because there's probably a lot of assets to deal with. But if it's uncontested and you have an original will, then that's there's no limit. Is there anything that could invalidate an original will, such as removing staples? No. You know, and we'll get to this down with the actual practice of the estate planning side, but typically when I'm doing a will or a trust, I have the client actually initial every single page. And then that way, if the staple is removed and somebody's trying to slip documents in, not only is the page numbering going to be messed up, which you can, you know, forge and alter and you know, mess with the page numbering, but it's going to be hard to mess with a blue ink initial on every single page. I have the witnesses and the testator initial every page. So removing the staple does not invalidate it, but the better practice is have them initial every page to prevent something from happening there. Okay, so requirements for a formal probate. Like I said, it's the end of the spectrum. And somebody's died. That's the only requirement that's necessary for a formal probate. And you can always do a formal probate. I'm going to blow through this pretty quick. Process, it's pretty much similar to an informal as far as you file your initial petition and notice at the beginning. But rather than the probate registrar reviewing it, now it gets scheduled with the judge. And so the commissioner will schedule, their office will schedule the hearing as soon as possible. Maricopa County, it's usually a couple months out. And so that's one of the things that makes this not as ideal for clients, especially when we have, you know, a pending real estate sale, or they need access to funds as quickly as possible. And so it kind of makes it difficult, cost prohibitive for them. And so we have to have that oh, here it is, the hearing date scheduled. Once the hearing is scheduled, we have to give the notice of the hearing, publish it for 3 weeks. And then we have some pre-hearing work. You've got to do some, as I'm saying this, I'm remembering, hey, I need to do a notice of hearing for a case. I'm writing myself a note. So we have to file and lodge orders of appointment and letters of appointment with the commissioner 5 days before the hearing. Then we have the hearing. At that point now, there's a few different ways it can go. I won't get into the details here, but basically at this point, it can either go litigation route where people are fighting and arguing over things, or it can go, if nobody's contesting it, the judge will just hear the evidence and rule. Or if it's contested, you can then go to a settlement conference and basically try to negotiate with one of the judges that gets assigned to settlement conferences. After somebody's appointed after that hearing, you file then the rest of the informal probate packet, training, orders, all that stuff. And then at that point, now letters are issued. You can have access to the assets. And then at that point, it proceeds as normal. You got to send the notices, accounting, inventory, all that. Like I said, informal can turn into a formal probate that then requires a hearing. So how do we identify it? Conflict. A formal probate is typically going to be, there's conflict involved. Not always, but most of the time, siblings are fighting. Parties are arguing over will, who's going to get assets, the will's valid, who should be appointed, all those things. So usually that's our signifier of a formal probate is required. Okay, next, tardy probate. It's better late than never. If you haven't seen this movie, we watch it pretty much every Thanksgiving. Trains, Planes, and Automobiles. It is pretty awesome. But better late than never, tardy probate. We talked about this a little bit before. It's basically the same scenario as a informal probate, except that we're outside that 2-year window. The difference here is the letters of appointment document is slightly different. And after that initial packet has been filed and approved by the registrar, that's where we stop. The letters of appointment are issued, and then we don't have to do the notices. We don't have to publish. We don't have to wait 4 months for creditors. It's done. At that point, you just file a closing statement after the assets have been distributed. And that's then the catch. The difference is rather than the personal representative having access to assets to use and manage during the probate, we're assuming that all creditors have either made a claim, had their chance to make a claim, they're outside statute of limitations, all those things. So we don't have to do that extra period. So there's no need for the PR to hold those assets. And so the letters of appointment specifically state that the property has to be distributed to the heirs. Here's the language for those letters of appointment. If proceedings are brought under this exception, the PR has no right to possess estate assets beyond that necessary to confirm title thereto in the rightful successors of the estate. So in plain language, that basically says the PR can't hold the assets. And let's look at the context of real estate. The PR can't sell the real estate and then distribute the cash. They have to deed the property with a deed of distribution to the rightful heirs under the will or under Arizona law, and then they can sell the real estate. And so that's going to be the difference. The title company, if they see these letters, they're not going to let the PR sign the closing documents. And that is important because in the context where if you can't always find the heirs or if they're all spread out and you're dealing with real estate, now all of those heirs have to sign the closing documents or figure some other way out, which then makes a real estate closing a headache and a nightmare of getting 5 people to sign in 5 different states. And so when I talked about being close to that 2-year mark, sometimes it's better to get the probate done prior to that 2 years so that we don't have this limitation. The PR can just sell the real estate and then distribute. Whereas in some contexts, maybe it's easier to just wait for the 2-year mark because now this part we don't have to do the notices. It's just done. We kind of skip that whole back end process. So depending on the facts and circumstances, it might be better if you're close to that 2-year. It might be better to wait. It might be better to push it up and get it filed before. Again, it's similar documents as an informal probate, except that we have to identify it's tardy and all that, and then we can skip the process. How do I identify it? 2 years. If you hear anything about an older probate, somebody died a while ago. I've had some of these where they died in the 90s and they're just now going to probate the assets. Obviously, that's 2 years. So that's going to be a tardy. So that's going to be your trigger for remembering this is a tardy probate. Next one, subsequently discovered property. Oh, you know what? Let me jump to some questions. Where are we? The original PR is appointed, doesn't complete the job. New PR is appointed in the court within a 2-year time period. Does that reset the clock? Ooh, that's a good question. I think it depends on what they're doing. I've had one where, I'm gonna say no. I'm gonna say that this is gonna be the process that they would do, is subsequently discovered property, which then let's look at real quick, and I think this might answer that question. I've been looking for you. So this is where we have property where there was an original probate and it was never completed, whether they meant to or something happened to that original PR. But for some reason that probate was done, but it was never actually completed. There's a 2-year time frame where if the court, 2 years from the filing of a probate, if it hasn't been done, the court will issue a minute entry saying, hey, what's going on with this? We either need a status update or you need to file a closing statement by this date. I think it's 60 days. And so if you don't do either of those things because your client is ignoring it, then at that point the court will administratively close the probate. And so this, if in that question context, if they filed it within the 2 years, or outside the 2 years, I guess, this is going to be the one that you will do to reopen the probate and deal with the asset that's left and then close it. So this is where, again, we have an informal probate that was opened or closed. Not everything was distributed. It does not have to be the same personal representative as was appointed in the original one. Requirements. There's property still owned by the decedent that was discovered after the estate was settled or closed, or the PR was discharged, or sometimes they thought they actually closed everything and distributed all the assets and they filed a closing statement. And so that's the context of subsequently discovered real property. And the good thing is here, you're assuming that the notice to creditors was done, but even if it hasn't, it's been over a year, or it's been 2 years and administratively closed. So it's been long enough where, again, creditors, hey, if you had a claim, you should have brought it. And so we aren't going to allow any new claims from creditors. The original probate, but for the most part, it's going to be a lot of the same. And then again, we skip all of that second half of the probate. Once the letters are issued again, they distribute the assets and then can close. Subsequently discovered. How do we identify it? There's a closed probate. So if you ever hear them say, yeah, there was a probate, but nothing, there's still this piece of property out there, that's going to be the trigger for this category. Ancillary probate, a tale of being knighted. So ancillary is going to mean we have a probate that's active in a different state, and we are coming to our court here and telling them, hey, we've got this open in another state, grant us the same powers here that we have in that state. And so that's an ancillary probate. The way that you do this is you file, it's called a proof of authority. I don't believe there is a form for this on the court's website. So if you have questions about it, let me know. I can help you out. But basically, you go to the court with the letters of appointment from your other state and file that along with the proof of authority, and then the court will grant that same power.
Is now joining.
That's the process. Again, it usually takes just a couple of days to get approved. And we don't have to do any of the notices here because it's assumed that that's being done in the primary state where the probate is being administered. And so, this is the one that you're going to get a lot with the snowbird community, where they're probably have the bulk of their assets in a northern state. And so that's maybe where the primary probate is done. But then they've got that, one property here in Arizona that needs to be dealt with. And so we do that proof of authority and get it done. The problem that I often run into here is we have a combination of subsequently discovered real property and ancillary probate, where probate was done up there, maybe a while ago and closed. And then we have the family realizing, oh, there's an Arizona property we didn't deal with. So now what do we do? The important thing here is the letters that we file here, the letters of appointment, they have to be valid because they're granting the same powers they have in Washington, let's say. So if in Washington the probate was already closed, and then we try to file letters of appointment here, the problem is Arizona is granting what powers you have in Washington. Well, if the probate's closed, you have no powers in Washington. And so you have to reopen the Washington probate using whatever that state's rules are for that, have valid letters of appointment, then now you can file the ancillary probate here in Arizona. So it might take some work, might take some cooperation with somebody in a different state to get that done. And then at that point now you can handle the ancillary probate here. How do we identify it? A different state. Snowbirds are often the triggering thing there. Okay, these are the dealing with the small estates that somebody asked about value. This is where that does come into play. Affidavit of succession to real property, where the smaller it is, the better. And here's the reason why. When we have small estates, we don't have to do an informal probate because the idea is, well, there's not going to be enough value here for creditors to even have anything to collect against. So we don't even have to deal with them with notice to creditors or anything like that. And so it's for small estates, and it is specific to real estate. It will only deal with one property. If we can meet the requirements, it allows us to do this hyper condensed version of probate. And the effect is it automatically transfers the property to the heirs. So here are those requirements. The decedent had to live, be a resident, or own property here. And the person signing the affidavit has to be the successor or successors in interest to the real property. So if there's a will and they are the beneficiary of this property under the will, they can do it. If there is no will, then it's going to be Arizona law that says who gets the assets. We need all of those parties, or if it's just one person, then they're the only one. They all have to sign the affidavit, which again is maybe a logistical headache of having to get 4 siblings to all sign and notarize this affidavit of succession. But the payoff is worth it for them. It also has to be more than 6 months since the decedent died. So this isn't for something where they died last week. It has to have been more than 6 months. Then this is the big one. We look at the equity in the property, and the threshold is $100,000. There's 2 different scenarios. So the first one is
all this time
if
just to get
no probate was opened anywhere,
it's
and
ridiculous.
no personal
I
representative was
I
appointed, then we look at
Four
the
words
equity of
that
the
say,
real estate
and you have
in
to write down
Arizona.
the 4 words and then send it to
If
them
there
to know.
was a probate opened under
If you
category B,
Let me get up.
discharged more than a year ago, then the equity has to be all real estate anywhere.
Her father
so
had.
That's where that can kind of come into play.
Her father had.
So looking at the equity, we look at what the assessor
permanent.
says is the full
He had to
cash
go have
value for the year they
every-
died,
My father
less
took
liens
Coumadin.
and encumbrances. That's going
I
to
have
be
say,
how
as
we
soon as my
calculate
father
that
took
100,000.
Coumadin, he went downhill.
Hey Brian, are you able to mute the attendees? I think there's a mute all button. Let me see if I can do that. Mute all. There we go. Let's do that. All right. Okay. Then the other requirements, let's continue. All the funeral expenses have to have been paid. Unsecured debts have been paid. That's the one that might prevent this for some people. No other person has a right to the property, and then no taxes, no estate taxes are due. If you can meet all of those requirements, then you have the affidavit of succession, which again, there's a form online for that on the court's website. Have all of the proper parties file and sign and notarize it, and then it gets filed. Once it's approved, then at that point you get a certified copy and you go record it with the county recorder, and that automatically transfers the property to all of the people who signed that document. And so it's very quick. At that point, you're done. There's no notices, no closing statement, anything like that. And so it's the very quick. We're talking a week, and this real estate can be transferred. How do we identify it? There's little equity in real property. Remember, $100,000 is that threshold. File one affidavit on multiple real properties as long as they all fall under $100,000, such as vacant lots. There's one affidavit required per property. I've actually never dealt with this, having multiple properties, because usually once you start having 2 properties, you're probably going to be above $100,000, unless they're just maxed out with debt. But I would. It's a good question. I would say you could try it all in one. And then again, you're telling the court that there's less than $100,000 between these two properties. And then at that point, you would record it, and then that would take effect for both of the properties. You have to put the legal descriptions of the property in there. So I would just put two different paragraphs, one for this one, property located here at this address with legal description as follows. Also property 2, and then the legal description there. Yeah, Don's saying he's done it, usually involves small parcels of land. So yeah, I would put it in one and then just record the one. Can the heir forfeit their right to distribution, give it to another? Yes. In general, you can always do that. A person can assign their interest, or they can disclaim their interest. Some reasons, there's all kinds of reasons, but disclaimers are usually used for tax avoidance. If you're going to get this inheritance and now be hit with some huge tax obligation, if it's a massive estate, we're in a position now with the current tax laws where that's not as common as it used to be. But there might be other reasons why you want to disclaim. If you sign a disclaimer of interest, it skips over you as if you never even survived the deceased. And so at that point, then it passes to the rest of the heirs, either under the will or the Arizona law. If you have, you can also assign, and that allows it to go to a certain person. And so if you have, let's say, 5 siblings who could and need to sign an affidavit of succession to real property, 4 of them can assign their interest to one of them, and then now only that one person needs to sign, but then now the property is only going to that one of them. And so you can do it, yes, but they have to know that they're giving up their right to the property. No, it doesn't have to be a formal. There's actually a checkbox on the form affidavit of succession where you can say either I am the right person to inherit this property, or all of the other people who have the right to inherit the property have assigned their interest to me. And then you attach all of the assignments and get that filed and recorded. Is there a time limit after death to the affidavit? Nope. It just can't be within 6 months. It could be 50 years ago, as long as that person is the right person. Now, again, we're looking at time of death. So unfortunately, if you're the great grandson of the person that died and nobody's probated it in the 100 years since that time, then you aren't the right person to be to inherit. Grandkids are, or excuse me, kids are. So your grandparents. So at that point, now you got to kind of chain together some probates, get appointed as PR, get appointed as PR, get appointed as PR, then you can file an affidavit of succession and then just deed it down. But that's a nightmare because now you've got to do air searches and all that stuff. Disclaimer deed, assignment form. No, it's not a disclaimer deed. There's a disclaimer of interest that's saying pass over me. Or there's an assignment of interest that says I'm taking, I'm entitled to this, but I'm giving that right to inherit to a different person. So it's not a disclaimer deed. A disclaimer deed is where somebody's going to receive property and they want to own it as their sole and separate property. At that point, then the spouse signs a disclaimer deed saying, yeah, I acknowledge that it's their sole and separate property and I have no interest in it. So that's where that disclaimer deed comes in. Okay, let's move on to affidavit of collection of personal property. These are dealing with small assets. Again, affidavit of collection of real property, affidavit of collection of personal property. Real property being real estate, personal property being all your stuff. And so this one it's similar, not quite as strict on the requirements. It's specific to personal property, and this one does not get filed with the court. All that you do is, we'll get to that in a sec. The requirements, again, have a connection to Arizona. The time frame on this one is 30 days instead of 6 months. So you have to wait 30 days and then you can do this. The person signing is the successor in interest, just like we talked about with the real estate. And then this is where it changes. Instead of filing it, it gets delivered to the person holding the asset to be distributed. So the classic example is a bank account. If you're the person entitled to that asset, but you don't want to go through this whole probate process, or maybe you need the funds in order to do a probate, you do an affidavit of collection of personal property and deliver that to the bank, and then they will review it and say, yes, okay, you're the one entitled, here you go. And then they turn the funds over to the client. Again, we have two different threshold ways of calculating it, but the number is $75,000. Again, so if no probate opened anywhere, then we look at the Arizona assets. If it's under 75, then we're good. If there was a probate open somewhere, then we have to look at all of the assets, no matter where they are located. Then that has to be under 75,000. If we can meet all of those, we can now do this, and it's very easy. Again, little equity in personal property. Okay, let's get to the problems that we have with probate. The biggest problems we have are the time associated with it, cost, conflict, and then intestate distribution of assets. I'm going to go through these quick because I want to get to the ultimate point is how do we avoid that? The problems are that it takes, with the time, if there's real estate transactions involved now, if there's formal probate, now we're having to wait months before we can actually sell. Maybe somebody needs the cash quick, and so they can't wait that time. All of those things cause problems with having to go through probate. And so it costs money. There's filing fees, recording costs, publication costs. You have to get certified copies. All of those things are reasons why we want to avoid this probate process if at all possible. Attorney's fees, your fees. I know there's some law firms out there that charge flat fees. Some do it just hourly. Some even charge a percentage of the estate, almost like a contingency fee. And so you can imagine those prices get up there pretty quick, which then becomes cost prohibitive if the only asset is, something very of little value, in which case, why even bother spending $5,000 for an asset that's worth $7,000? And so it just doesn't really make sense. It also invites conflict. We have family members fighting over assets, over who should be appointed, over whether the will is valid or not. And all of those conflicts only delay the process even more, because now we've got to have hearings and figure things out. Now, this is then, to me, the biggest problem with probate and then improper planning for estate planning, which then gets solved with what we're going to talk about next. Arizona intestate succession law. So if you don't have a will, Arizona statute controls what happens to the assets. And the problem there is that it's, those laws have not been majorly modified in a long time. And so to me, they don't quite fit with the current culture and how families are. And especially in the context of a blended family where we have children from prior relationships and then families are merging. Arizona intestate succession often leads to very unjust results in those contexts. It doesn't often protect minors very well, and it definitely is not going to reflect how the decedent would have wanted their assets to be distributed. Brady Bunch and Richie Rich, those are the two examples of the problems with Arizona intestate succession law. So here's the statutes themselves. So 142101, any part of a decedent's estate not distributed by a will goes by intestate succession to the heirs as defined in this chapter. So how is heirs defined under 2102? Everything goes to the surviving spouse, unless the decedent had children from a different relationships. That's the blended family that I'm talking about. So we have deceased, let's say the husband passed away and he had children from a prior relationship. He remarries, and the wife survives him. Then in that scenario, we get to the second part. The surviving spouse gets half of his separate property, and the children, his children, get the other half in equal shares. The spouse gets none of husband's community property because she has 50% of it already, and the kids get 50% of, or get all of his community property. So assuming things are held correctly, it's usually going to be a 50-50 split. But things can get very messy depending on if something is separate property, community property, or if it's held as tenants in common. That's usually where we get into some very unequitable distributions of things. Intestate distribution of assets. Under 2103, if there is no surviving spouse, then everything passes to the descendants by representation. So that means everything goes to kids. If there's no kids, then it goes to grandkids and goes down the line. If there's no one down the line, then it goes up to parents. If there's no parents, then now the last one, we go to siblings and down their line to, nieces, nephews, all that stuff. It works its way out until it finds somebody that's alive. It might be the third cousin of the person that died, but it's going to find somebody alive. And so the problem here is that, one, it might not be how the decedent wanted their assets done, but two, we get into some problems with if it goes to grandkids, they might be minors. What do we do in that scenario? Well, it's going to be held. A conservator is going to have to be appointed. They're going to have to manage the funds. But as soon as they turn 18, and that's why I mentioned that it's a problem, as soon as they turn 18, that child is going to get their entire share. I don't know how responsible you all were as 18-year-olds, but I know that I would have blown that in a heartbeat. I probably would have gotten on some trip or bought some car and blown it all. And so if we can avoid that at all, if at all, that's where it's important. I want to go back to the blended family, and I'm going to use a couple specific cases that I've had where this is perfectly clear. The first one is the deceased, the dad. It was the scenario I said. Dad had children. He remarried. He died, and at that point, half of his assets went to the kids. Half of his assets went to the stepmom. The stepmom then died without doing any type of will. And what happened when she died? It goes to her heirs. So, who are her heirs? Her children, not her stepchildren. It goes to her children. Well, she didn't have any. Her parents, she didn't have any. It was literally the case where it went to her third cousins in Texas who claimed they remembered her from family reunions. They didn't know who she was, but they got all the money. The problem there is trace the assets. Dad had the bulk of the assets. He died. Half of it went to stepmom. And then now, when she died, half of dad's assets are going to some people that my clients, the sons, had never heard of, never met. The stepmom probably never heard of or met. And so it ends in a very unjust scenario for those kids who didn't get their dad's assets. Now, in that one, we made arguments, we settled, we were able to get them a lot of their dad's assets. I'm going to jump to this question. Let's see. Adding a clause stating that certain children from previous versions get nothing. Does this have a lot of weight with the court? The child gets nothing, or is the waste of time if the court eventually gives something to the child? No, if you're I'm assuming you're talking about in the context of a will, you can disinherit anyone under a will. And that's the nice thing about doing something and not letting Arizona law control is because if you draft the will, you can now put your specific wishes. If you don't want that child to receive something, then you say, I specifically disinherit this person. And so now, again, the court wants to honor the wishes of the deceased. So they're not going to say, no, they're a child, they're going to get something. You can disinherit them. And the court's going to honor that as a valid provision. Let's now move on to how do we avoid probate? So we've just talked about all these problems and processes of probate. How do we avoid all of that? We don't want to even have to go to an informal probate or even an affidavit of succession. It's still time and money that they're having to spend to deal with these assets. So rather than putting everything off till the end, till after they've died, the person can do something now. And so that process is estate planning. We can use trusts. We can own assets with right of survivorship. We can use beneficiary deeds. And the one that's not on here is payable on death accounts for bank accounts. All of those things are considered non-probate assets. And so the idea then is if you could put all of your assets into some vehicle that is non-probate, like those mentioned, then when the person dies, we look around at, well, what did they own? Hopefully the answer is nothing. Either they didn't own it or they owned it in one of these vehicles. And so there is no probate required. And so at that point, then we just administer these things and everything passes automatically. So let's jump into it. Trusts. Trust is the biggest way to avoid probate. You can jimmy rig, and we'll talk about some of these, go back to the rights of survivorship and beneficiary deeds. You can kind of piecemeal stuff together, but a trust is the comprehensive way of avoiding probate and protecting everything. So a trust is a non-probate asset. The idea is you execute the trust, you sign it. Now it exists. It's almost like an entity, like a LLC or a corporation. It can own assets. So once the trust is created, you convey all of your assets to the trust. And then now when you die, again, we say, what did you own? Hopefully nothing. The trust owned it all. The trust more or less mirrors a will in that it identifies who are the beneficiaries that are going to receive the assets. You can nominate guardians for minors. You can then appoint a successor trustee who, and their job is like a personal representative, but instead of having to go to court to do all of their power to have that granted to them, the trust just automatically does it. So when the person dies, the successor trustee now steps up. Their job is gather all of the assets, do the notices, pay creditors, and then distribute. And you don't have to go to court for any of it. That's the nice thing. And then I'm going to go back. Testamentary trust. This takes care of the minor problem. A testamentary trust says, I'm going to leave my stuff to my kids when I die, but instead of giving it to them as soon as I die or as soon as they turn 18, I'm going to delay these distributions. So each child gets a share, and then when they hit the certain benchmarks that I put in the trust, they get a distribution. So I can say, they get half when they're 25, half when they're 30. At that point, then the trustee, their job is to manage it. So they have to, then when the child turns 25, they get half of the amount that's in their trust. And so during that time, before they hit those distribution points, the trust is then used for it's the health, education, maintenance, and support of that beneficiary. And so, it's going to be able to use, they're going to be able to use the assets for college, tuition, whatever, basically the trustee has discretion. Maintenance, that's a pretty broad category. So they're going to be able to use the assets if the trustee agrees to do that. And then at their benchmarks, that's when they're going to get distributions of the cash that's left. So that's one thing that, and the biggest way that we can protect minors from that, 18-year-old getting a bunch of money and blowing it all. The other benefit of a trust is when we're dealing with probate and wills, each spouse has to have their own will in order to identify their wishes. So when spouse one passes away, maybe you can do some non-probate stuff with rights of survivorship, but if there's anything outside of that, you have to probate the first will. Then when the second spouse passes away, you have to probate that will. So it's doubling up the cost for a married couple. Whereas with a trust, you create a joint trust. Both of them are trustees while they're alive. They can manage the assets, they can use them as their own, they can take out liens on them, they can sell them, they can add assets. They can always amend the trust. But then at the point where the first spouse passes away, nothing happens, nothing changes with that. Again, that's where it's different from probate. We don't have to do anything. When the second spouse passes away, that's then when the trust locks in place and becomes irrevocable. And now the successor trustee steps up to manage that trust and administer it. And so that's the biggest benefit of a trust, is it now cuts those costs in half of having to double up on probates, double up on wills, and all that. So that's why we like trust. I'm going to jump to some of these questions now. An art collection into a trust. yeah, it'd be considered personal property when it's called funding the trust, where you've created it and now we're putting the assets in it. Real estate, you just do a deed, right? You create a deed that says I convey it from myself to myself as personal representative of the trust, or excuse me, as trustee of the trust. That takes care of the real estate. Your other stuff, if it has a title or an account name, you go and you take the trust to that, bank, for example, and say, hey, we need to change the name of this into the trust. They'll then fill out the paperwork and do whatever they need to put it into the trust name. At that point now, the only difference is your checks will read as trustee of the trust. But with things that don't have anything like that, our software generates two documents. It's the comprehensive transfer document and a bill of sale. Client signs both of those, and it basically says all my stuff, laptops, blenders, couches, art collections, those things all are now part of the trust. And so at that point, then we would say, yes, it was conveyed to the trust while they were alive. The trust owned it. If there is something, that you don't want to take a risk on, you could maybe have them sign some type of like assignment of art collection, where they're actually specifically saying, see exhibit A, and then identify each piece of art by name or by picture and say, we are transferring our ownership of this to the trust. You can kind of do that however you want. That's maybe one way. How does it work for nominating guardians of minors when the creator of the trust is no longer married to the other parent? Yeah, so I'll say this. I don't deal with family law, but the divorce decree is going to control, right? We can't get out of custody things that have already been decided by using either a will or a trust, and both of them will deal with guardianship. And so essentially, if the parent passes away, whatever the divorce decree said is going to still control. The other spouse is going to get custody of the child unless it was completely severed. The context of where you still identify it is if something happens to the other spouse and now both of you die. Either they died first and then the other parent dies. But at that point, then that's when it's going to follow the wishes of whoever died second. And so that's why we still do that, even if there's a divorce decree entered. Ancillary probate, case of out-of-state closed probate. I believe you can do an informal probate in Arizona because there is a place on their forms where it says, was a probate open in another state? If so, you identify where and if the probate or who the personal representative was. I usually recommend the other way because it's probably cheaper. It's probably cheaper for them to go open up a probate and do an ancillary probate than having to file a full-blown informal probate packet here, where they with the asset that it was filed in the county. It's where they died, owned assets, or lived, and so it's usually going to be, if they own assets here, you can always open the probate here. Okay, let's move on to some of these other little non-probate transfers. A real estate, owning it with rights of survivorship, that avoids probate. So you own it as either joint tenants with rights of survivorship or community property with rights of survivorship. This is done on the deed where they're taking the interest, and they have to sign an acceptance of that right of survivorship, or else it's invalid. And so if I'm conveying property to a married couple, they would own it as community property with right of survivorship. I sign the deed, obviously, as the grantor, but the difference is they also need to sign accepting that right of survivorship. If that's the case, if they've done that, then at that point you record the death certificate after the first spouse dies, and that their interest automatically transfers to the other spouse. So that's one way. Again, it's one way to avoid probate with the first spouse, but then if the second spouse never does anything, then their interest is still going to have to be probated because they don't, they didn't do anything to plan for it. So that's the downside. Beneficiary deeds, that's the other way to avoid probate. If the only asset, if a client can honestly tell me the only asset they have is real estate, then I'm fine to do this. I will almost always try to convince them to do something else. Because, like I said, if anything else comes up outside of that, they're having to deal with a bank or anything like that, that person is going to require letters of appointment from the court in order to even communicate with them. And so a beneficiary deed, great, it can transfer the real estate, but there's going to be something else that's probably out there that would necessitate a probate. But you can piecemeal it all together, like I said. So a beneficiary deed says, upon my death, I want the property to go to this person or persons. And so you identify them when they die. The grantee dies, grantor dies, they record a death certificate and it automatically transfers it to those beneficiaries. You also identify contingencies if the beneficiary dies before the grantor. If in that case, it's going to say it goes back to the estate, or just this whole deed becomes null and void. The downside, again, it doesn't control any personal property. So we've got 3 minutes. I want to try to stay on track for Don. I'm going to actually skip the questions because it's a little hard to interact on here. So I'm going to skip through these. We'll go through some real life examples after I answered this question. Beneficiary deed, what happens if the named beneficiary files beneficiary after the grantor died? It is. That's the other key component of a beneficiary deed. It must be recorded before death. And I've had this come up. They found a beneficiary deed, but it was never recorded. Signed before they died, but it was never recorded. So it's an invalid deed, which is unfortunate, but that's the other thing. You got to make sure that gets recorded. A couple of the real life examples that I had come up with, where it kind of puts a lot of this into perspective is, I had a client whose mom remarried and the mom passed away, and I think it was within 2 months the stepdad passed away. Again, it's the scenario with a blended family where half of the assets go to dad, half of the assets go to child, and then stepdad now, child doesn't have any right to inherit the assets from the stepdad. The problem here is the stepdad, after the mom had died, the stepdad didn't do anything, didn't do probate, didn't really transfer assets, but there was some fraud on their joint bank account, which is where most of the assets were. So the bank closed the account and then just reopened it in only his name. So he ended up actually taking, I don't think there was any ill will here, but he ended up getting 100% of the bank account and the daughter didn't get anything. So we're now having to figure out how do we go get access to the bank account because she's entitled to at least 50% of it. So we had to go and get appointed as personal representative for the mom's estate and say, I can now act on behalf of the mom's estate. Now we are having to then go file as a creditor against the stepdad's estate to say, hey, that estate owes 50% of the proceeds back to the mom's estate. And so, that's one thing. You have to get creative sometimes of putting things together to get the job done for your client. Another one, this is really unfortunate. I had a client who is a real estate investor, and they were 2 days away from closing on the real estate, and the seller died. And so then we're left with, who can now perform under this contract? Nobody. She didn't have kids, she didn't have parents, no siblings. So we are now having to do an heir search, find some random person who's going to be the heir, and try to get them to cooperate with us and say, look, we just need you to get appointed so that we can sell this property, and then you can go and distribute the assets according to Arizona law. And so at that point, the problem if we can't find an heir. And so then we might have to file a lawsuit for breach of contract. I know it's a little weird and morbid to say that the dead person breached their contract, but if that's what it takes to get the job done, that's what we're going to have to do. The last one, this was a very interesting one that just came up this last week, was there was a trust. Great, it was done. They administered the trust. My client was one of the beneficiaries who just got a small amount, but then a year after the trust was done, stepdaughters of the deceased came out and said, hey, we've got this divorce decree saying that, yeah, stepmom got the house, but it says when she died, the house goes to us. And so now we're left saying, well, we already distributed the assets, and now you're wanting the trust. So they said, well, no, we'll just take the cash. So now the beneficiaries, according to the stepdaughters, the beneficiaries need to pay back their amounts that they were distributed so that they can give it to them. So we're arguing that, and we're contesting it, and all this stuff. But even with good estate planning, you can still run into problems. Now, in that case, the trustee did not do any type of notice to creditors as part of the trust administration. And the statute says that they may, it's not a requirement, but had they done that, then these stepdaughters would have been wiped out because they didn't make their claim on the property. So even though there's some statutory things that are allowances and not requirements, best practice is if you're ever doing a trust administration, still do your notices as if it's a probate, and that way now creditors are wiped out from making any claims. That's all the time I've got. I know we started a little late, but I don't want to throw the whole thing off. So Don, I'm gonna turn it back over to you here, and yeah. So if you ever have any problems, things get outside your scope of what you can do, or even if you just have questions, and you're seeing dead people on title to real estate, or something like that, you're gonna call me. Don't call Ghostbusters; they won't help. I can't. So I'm here to help you guys in any way. I get questions all the time from people that attend these classes, just saying, "Hey, I've got this scenario. What do you think?" And I'll point you to statutes or whatnot, and help any way I can. So there's my contact info. Don, I'll turn it back over to you now. Thanks.
Okay. All right. Thank you, Dustin. I don't know if there's a feature in this system where we can all clap, but you can clap in the privacy of your homes, or maybe on the little chat feature, you can write clap, clap, clap. But anyways, terrific presentation, Dustin. We really appreciate it. And I just to kind of add what I know Dustin talked about a little bit is that if this is something, that I'm always trying to promote document preparers to get in to expand their services if they can. And this is a much needed service. It's a profitable service that you can provide your clients. And there's a lot of information out there, the least of which is not on the court's self-help website that you can use to kind of get that all started. And so I highly recommend it. In my personal practice, when I was in private practice, I did a lot of probate work, and quite honestly, I figured it out myself, and it was not really a big deal. And now, obviously, there can be things that are a very big deal with probate, but for the most part, most of the situations you run into are not that big of a deal. And getting referrals for that kind of business, when I was into it, I got a lot of referrals from realtors, from title companies, and just from old clients. So anyways, highly recommend it. Again, thank you very much. Now, we're going to take a 5-minute break, but before we do that, I want to repeat what I said at the very beginning of the seminar about our verification process for participating in the webinar today. And that verification process being that throughout the course of the webinar, I'm holding up 4 different words, and you need to write down those words, each of the words, and and at the end of the seminar, sometime shortly thereafter, you want to send me an email. So, and that's all in the instructions that everybody got. Send me an email and list the words, and then that will get me to send you back your certificate of completion, which I will actually probably won't be able to do for a couple hours afterwards. But I promise you, I will get it to you by at least by the next day. Today, we're going to be talking about just ethics in general, as well as I should switch to the next screen. Here we go. So we're going to talk about what is ethics. We're going to talk about ethics in general. It's a little bit of an abstract talk about the subject briefly, and that's going to include going over ethical standards, a framework for ethical decision making. And then we're going to kind of relate that to our program, our world is certified legal document preparers. We're going to talk about and review CLDP roles and responsibilities. And then the bulk of this part of the presentation is going to be about the complaint process. I'm sure nobody in this audience, well, maybe a couple people, has been involved in the complaint process with the Board of Legal Document Preparers, but it's certainly wise to have a good idea about how that works. And so that's going to be the bulk of this presentation. We'll have some examples, or at least one big example that I'll talk about. And then we will get into talking about different ways that document preparers kind of protect yourself from entering into that process, or at least set up a situation where if you're in that process, maybe your business operates in such a way that you have information that that will help you avoid issues, avoid problems that often come with that process. And then finally, at the very end of the process, I'm going to talk a little bit about the status of the limited license legal practitioner, where that's at, and we're gonna see where that's at, which that particular process is really going through very quickly, and so we'll go through that. But so now let's talk about CLDP ethics and get into the complaint process. So what is ethics? So ethics, a good definition for ethics pertain to the beliefs that we hold about what constitutes right conduct. Now, ethics are moral principles adopted by an individual or group to provide rules for right conduct. Ethical conduct is a result of a combination of knowledge and a clear concept of the philosophical principles that underlie an ethics code. So I'm following along in a couple different ways. Excuse me. Little delay here. Oh, apologize for that. Here we go. Okay. All right. So what are some key components of professional ethics? You have, values that pertain to beliefs and attitudes that provide direction to everyday living. So examples of values, people have personal values, so honesty, reliability, trust. These determine how you'll face the world and relate to people. You have cultural values, like the practice of your faith or customs. Those are principles that sustain your connection with your cultural roots. You have social values. So social values are principles that indicate how you relate meaningfully to other people in social situations, including those with family, friends, and coworkers. So work values are principles that guide your behavior in your professional life. They define how you work, how you relate to your coworkers, your bosses, your clients. They also reveal your potential for advancement. Morality, as a definition, morality is concerned with perspectives of rights and proper conduct, and involves an evaluation of actions on the basis of some broader cultural context or religious standard. And then finally, professionalism has some relationship to ethical behavior, but it's possible to act unprofessionally and still act unethically. So, or I should say, possible to act professionally and act ethically. That's an odd concept, I know. Now, ethical standards. There are a few different ethical standards I'm just going to briefly talk about, like there's a utilitarian approach. Some ethicists emphasize that the ethical action is the one that provides the most good or does the least harm, or to put it another way, produces the greatest balance of good over harm. You have the rights approach. So this is a model that suggests that ethical action is the one that best protects and respects the moral rights of those affected. This approach starts from the belief that humans have a dignity based on their human nature per se, or on their ability to choose freely what they do with their lives. You have the virtual approach. So this is kind of an ancient approach to ethics. It's an ancient approach that is ethical actions ought to be consistent with certain ideal virtues that provide for the development of our humanity. So these virtues are habits that enable us to act according to the highest potential of our character and on behalf of values like truth, beauty, honesty, courage, compassion, generosity, tolerance, fidelity, integrity, fairness, all those virtues that many of us strive for. So, the question that you ask if you're taking the virtual approach is, what kind of person will I become if I do this? Or is this action consistent with my acting at my best? So, if we put this all together, each of the approaches help us determine what standards of behavior can be considered ethical. So there are still problems that are to be solved. Like the first problem would be is that we may not agree on the content of some of these approaches. So we may not all agree to the same set of human and civil rights. We may not agree on what constitutes good conduct. We may not even agree about what constitutes harm. So those are all issues that we grapple with when we're trying to engage in a particular ethical approach to decision making. Going through. Okay, so what are some frameworks or a framework for ethical decision making? So one thing you want to do is you want to recognize the ethical issue. So is there something wrong personally with your skills, your competence, your ability to timely perform services? Is there an appearance of impropriety, a potential conflict of interest, etc.? Could the conflict, the situation, or the decisions be damaging to the client, third parties, or to the community in general? The next part of this framework is you get the facts. What are the relevant facts of the case? What facts are unknown? Who has the important stake in the outcome of what you're going to be doing? Do some have a greater stake because they have special needs or because they have a special obligation? So, in other words, who is impacted if I kind of screw up this situation? The next is evaluating alternative actions from various ethical perspectives. So what are the options for acting? Have all the relevant persons or groups been consulted? If you showed your list of options to somebody you respect, what would that person say? So in other words, do I have resources? Do I have sample forms for what I'm doing? Do I have access to a procedure list for what I'm doing? Those are all related considerations. And then, evaluating alternative actions from various ethical perspectives. I talked about that. The next is making a decision and testing it. So this is an ethical framework that some people might utilize. If I'm utilizing the utilitarian approach, the ethical action is the one that produces the greatest balance of benefits over harms. If I'm using the rights approach, the ethical action is the one that most dutifully respects the rights of all people that are affected. If I'm using the virtual approach, the ethical action is the one that embodies the habits and values of humans at their best. These are ways, again, this is an approach to making the decision making. So now how does this relate to our world? Let's start to relate this to our world as document preparers. Ethical issues in document preparation are regulated by both laws and whatever professional standards we develop individually or as a group. So ethical issues in document preparation are the law defines the minimum standards society will tolerate. So these standards are enforced by the government, including our beloved Board of Legal Document Preparers. Ethics represents aspirational goals or the ideal standards set by the profession, and in our profession, they're self-enforced. The minimum standards for CLDP are stated in our LDP code, which includes our code of conduct. So now, just to kind of look over the general purpose of our code, the court recognizes that the need to protect the public from possible harm caused by non-lawyers providing legal services has to be balanced against the public's needs for access to services. So, this is the magic consideration with really all non-lawyer services that are authorized out there. Now, I believe that this is what independent paralegals showed back in 2002 to the court and the public that resulted in the LDP program that we have right now. And I think it's valuable to remind people about what happened back then. When I talk about back then, I mean back in 2002, just before our code was put together by the court and other people that participated. As some of you that were practicing back then may recall, even to go back further than that, back in 1988, I believe it was, there existed a UPL law in the state of Arizona. It was a statute. And the lawyers of the bar kind of got in a little spat with the legislature about the bar not wanting to reveal information about attorney disciplinary matters. And as a result, the legislature sunsetted the UPL statute that was in effect back then. So from that point on, what I referred to myself back then, and a lot of people did, independent paralegals popped up all over the state. Most of which were probably here in Maricopa County, but a lot in Pima County, Pinal County, and around the rest of the state, and started to engage in all types of business, unregulated, and that continued for throughout the 90s. Really without much of an incident. There were a couple times throughout the 90s that the bar attempted to reenact the UPL statute, and each time it was defeated. I believe because of the efforts of some of us that would band together whenever the emergency would come up and go down to the legislature and speak to the powers that be, and they always supported us. So fast forward to 2001, I believe, is when this happened, where the bar decided that they were going to take a different approach and attempt to legislate us out of existence by doing a Rule 31 change, a change that kind of clarified, or some would say redefined, the definition of the practice of law. And we meaning the independent paralegals that were around at the time, caught wind of all this. And so we ended up forming what is now our Arizona Association of Independent Paralegals, and mostly with the idea of trying to band together and combat whatever was going on, because we wanted to continue to do business. And at the time, one of the major argument that the bar had against independent paralegals continuing to do business was that there were lots of complaints out there about document preparers and engaging in the unauthorized practice of law. So in order to protect the public, the Supreme Court needed to take some action so that we couldn't do that anymore. And at the time, I'm going to get this number a little wrong, but there were over 400 complaints out there. And what we did, one of the things that we did is that we somehow, and I think those of you who know Alan Merrill, I think facilitated this initially. Somehow we got in touch with an organization called the Institute for Justice, which is kind of the libertarian equivalent of the ACLU, and sought their help in addressing this matter. And long story short with them, they ended up writing a letter to the Supreme Court asking to allow us, the interested parties, the stakeholders, the independent paralegals at the time, to take a look at those 400 and some odd complaints to see what the nature of the complaints are, since this was really the core of the argument at that time that we needed to be legislated out of existence. And I was one of those people. Alan was one of those people. There were a few other people that were allowed to go to the bar offices and basically took out stacks of files and let us look them through all of them. And we came up with a system to kind of categorize what all the complaints were. And I think Alan Merrill is listening to this webinar, and please insert whatever I get wrong on this if you recall. But I think the long story short is that there were ended up being very few consumer complaints. I want to say 3 or 4 or 5, and it was very clear that this was not not a legitimate basis to do what the bar was asking the court to do. As a result, the Chief Justice at the time created an ad hoc committee that Alan Merrill and I were on, and there were a couple other people on it as well, 3 or 4 other people from our community, and I think their lawyers, a couple of them, and we got to sit in a room with a bunch of people from the bar and some other interested parties, and hammer out what became our current LDB code. So the point of me telling this story is just so people know the story, because I think it demonstrates what power we can really have as a group if we really want to combat something. And just as a side, we did other things as well. We picketed the Supreme Court. We approached the media and asked them to write articles about what we do and the benefit that we are to the community. We also picketed the bar's annual meeting in the middle of July in Tucson, and so it was a big effort, and it was very successful. So since then we've been in business since that was hammered out, since 2003, and so that's how we in a nutshell how we got to where we are now. And my point is that I think that's a battle that we're always engaged in, that the battle being proving repeatedly to the legal community, the court, attorneys, to to a lesser extent, I think the public, because they know us, that we that we do them no harm, that we provide access to justice. And so later on today, we'll also talk a little more about that access to justice as it relates to the new tier. But it's all, really the same issue. So this is the purpose of the code. This is, the underlying purpose that, the court recognizes that the need to protect the public from harm has to be balanced against the public's need for access. And it was determined that their need, that we provide that access to legal services for the general public. And by the way, any questions or comments on any of that, please feel free to chime in, and I'll try to respond to them or read the rest of the attendees what your comments are. So, within the code, and based upon that underlying, consideration, We have, certain roles and responsibilities as certificate holders. I'm hoping all of you know these, but we'll review a few of them. Certified legal document preparer is authorized to prepare and provide legal documents without the supervision of an attorney for an entity or a member of the public in any legal matter. And that's very important. There's been a lot of talk over the last few years about whether it really includes any legal matter, but right now, that's what the code says. So, and of course, that is for when the entity or person is not represented by an attorney. LDPs can provide general legal information, but may not provide any kind of specific advice, opinion, or recommendation to a consumer about possible legal rights, remedies, defenses, options, or strategies. Put very simply, we can talk to people about generally what people could do, but we cannot tell you what you should do. And I'm sure we can talk about that issue a lot, but again, at the time that we developed this code, I think there was the general consensus among the people on our side that it's having language that's a little bit vague like this serves us well, and I think it has. Although as of late, I think it's also been used against us a little bit because the language is a little bit vague. LDPs can provide general factual information pertaining to legal rights, procedures, or options available to a person or in a legal matter when that person is not represented by an attorney. Again, we can provide factual information about any legal matter. That would include rights, procedures, and options. But as it notes in the previous slide, it cannot be specific advice for that specific person for that specific person's situation. We can make legal forms and documents available to a person who is not represented by an attorney. So we can, draft, whatever whatever we want. We can draft forms that are complaints, that are contracts, that are wills, that are trusts, that are probate forms. We can draft them as we see fit. Obviously, so long as they are fit for the purpose that they're drafted for. We can file and arrange for legal services, for service of legal forms and documents for a person in a legal matter when that person, again, is not represented by an attorney. Now, let's talk a little bit about the LDP Code of Conduct. I'm scrolling down to my notes on that issue. So, and I want to review, let's go through the Code of Conduct a little bit. Now, as I go through that Code of Conduct, please use the chat feature if you'd like, if you want to make any comments, or at the end of this particular section, if anybody wants to chime in and make a statement, turn off or turn on their audio, I'm happy to do that, but send me a little message that you intend to do that first. So the first section I'm going to talk about is in the Code of Conduct is ethics. So a legal document preparer shall avoid impropriety and the appearance of impropriety in all activities, shall respect and comply with the laws, and shall act at all times in a manner that promotes public confidence in the integrity and impartiality of the legal system or the judicial system. To me, that's kind of a catch-all thing as it relates to the complaint process. I think if we do anything wrong, we're probably going to see that as one of the basis or one of the grounds for whatever it is that we did wrong. Let me see. I'm getting ahead of myself here. We're still in the Code of Conduct. The next part of the ethics heading is a legal document preparer shall be alert to situations that are conflicts of interest or that may give the appearance of a conflict of interest. So what are some examples? Taking business from adverse parties, like in a divorce, for example, and I don't hear about this happening too often anymore, but I know it wasn't unusual for some document preparers a while back for them to do the divorce paperwork and then also solicit the respondent and do the answer. And in my humble opinion, that would be violating that provision and maybe other ones as well. But there can be issues about whether or not it's okay to do certain things. Like, let's talk about the friendly divorce, where you have husband and wife come in, they want to get a divorce, everything's hunky dory as far as them filling out the paperwork, they want to do it together. Issues that you have to deal with are, who's the client? Is the client the petitioner? Is it the respondent? In my practice, when we would do things and we would have people come in with those situations, we would make it very, very clear. And at one point, we would do this in writing, but we would make it very, very clear that the petitioner is our customer. If they leave today and the petitioner calls and said, "Hey, I want to change this and that," that's who we're going to listen to, not the respondent. Other problems can arise, or related problems, when you deal with money and this would happen periodically, where the parties are coming together, one party is the petitioner, but the other person wants to pay. And so, some ways of getting around that, of course, would be say, okay, you give the money to that person and then that person will pay us. But those are issues that arise. Those are typical issues that might arise that cause concern from an ethical perspective. Other related matters, let's say you have a dual relationship. You're an LDP and an insurance agent, or a realtor, or a plumber. Are those relationships potentially a problem when you're operating as a CLDP? Those are things that you should consider. I welcome any other similar issues if somebody have questions in that regard. Let's see, and I should probably.
You probably want to advance the PowerPoint too.
Oh, yeah.
Sorry.
I'm going to check and see if there are any questions. So,
There's no questions. Yeah, there's one.
So I think I've given an example of the appearance of impropriety. Oh, can I provide an example of the appearance of impropriety? Yeah, that's a good question. As I think I said earlier, I see examples of those sort, or I see that when I look at when I try, and I do this, I track sometimes online who has complaints filed against them, what portions of the code people are citing with those complaints, and often, whether, no matter what it is, let's say it's somebody writing a motion, maybe citing some legal authority. Maybe they even have a template of their own. Let's say it's just a motion to enlarge the time to serve somebody a petition for divorce. And for whatever reason, something goes wrong and that ends up in the complaint process. An issue may come up about, citing the particular rule that deals with that, with expanding the time. And so, how that information came to be, even if it was something that you had let's say you had it in a template, which I frankly think is perfectly fine, but that may raise an issue of impropriety because maybe it may be seen as advising the client that this is the appropriate rule to cite in that type of a motion, which of course it is. But if we're not supposed to give any specific legal advice, is that violating that, or is that the appearance of impropriety? So that might be one example. I'm sure there are many. If anybody has any other examples, please provide them. So next on the list is under ethics is a legal document preparer shall promptly make full disclosure to a consumer of any relationship which may give the appearance or constitutes a conflict of interest. This can involve the obligation to inform a prospective client you provided services to their former spouse, to a business they may want to sue. Maybe you do business with them, or maybe it's your business or you have an ownership interest in that other business. I'm being asked to forward my, what I'm going through right now is in the code of conduct. I don't have it on the PowerPoint. So if any of you are wondering if I'm not advancing it, that's why. I got a question. Are there any statistics available as to how many complaints are made? Let's see. How many complaints are made by consumers versus lawyers versus judges? I don't have those statistics. However, when we were, back in the day when we were reviewing all those 400 and some odd complaints that were filed, the vast majority of them were complaints by lawyers, lawyers or judges, and basically a lot of them were complaints about advertising, where someone would just say, hey, this person does divorces, they're engaging in the unauthorized practice of law. I don't hear about any of those type of complaints anymore. Just in my unscientific review of what I've seen out there, a lot of them are continue to be submitted by judges and or attorneys that might be involved in cases. I'll get into this a little bit later, but a big problem I have with some of these complaints is the vagueness of the complaint. Not just kind of assuming that some of them that I read about, they just say something to the effect, I don't like, it appears to me that this document is done in such a way that the document preparer had to have given legal advice. And so, they don't know that, and they don't know how it was done, and yet it is processed anyway as a complaint. And I don't know how often that comes up, but in answer to the question, I don't know what the stats are. I suspect, and in my review of those type of things, it is usually the consumer complaints are far and few. It's mostly somebody else in the legal community who are complaining about something. Okay, so to just kind of move on through the code of conduct, the legal document shall refrain from knowingly making misleading, deceptive, untrue, or fraudulent representations while assisting a consumer in the preparation of legal documents. It goes on to say a legal document preparer should not engage in unethical or unprofessional conduct in any professional dealings that are harmful or detrimental to the public. Well, okay, that's reasonable. So, as this relates to advertising, the use of certain words can be a problem. Obviously, one would be if you happen to have a law degree. If you happen to have a law degree, you cannot. It is misleading. To what authority you have as a document preparer to state that you're an attorney or a counselor or some type of similar synonymous word. There may be issues with certain words in certain communities. Like a big one for a lot of years, and I think this continues to this day, is the use of the word notorio. If you're saying you provide those services, but using that word in the Hispanic community can often have a different meaning, that you're more of an attorney. And so, utilizing those words can be problematic. Question, this kind of goes back to the preparation of legal documents. Do you suggest not citing legal authority in our pleadings? Well, first, the big disclaimer, I'm not, I'm not giving you advice on this. But I'll tell you, I think there is an appropriate way of doing so. That may be changing, but what I mean by that is that if if you're using templates that use the same, you've created a template to do a particular document, and that template cites a statute, for example, or a court rule. I think if that template is something that you all use all the time, I don't know why that would be a problem. You're not, you're being asked to prepare a legal document that asks the court to expand the time to serve a pleading, just by way of example, and you have a standard template that you use for that purpose. I think there's a very strong argument that you're not tailoring it to the client's needs. You're not giving advice. You are saying, and you say this with any document, that this document is properly prepared for the purpose that we're using it for. And certainly it's reasonable for clients to rely on that. But I don't think that you're not going and doing specific legal research for this specific client. And now, should you regularly update the templates that you use for such purposes? Absolutely. But you're not doing it specific for this client. One of the issues that I had with the proposal to modify the code about a year ago, some of you may recall the board, or I don't know if it's technically the board, but let's just, for our purposes today, say it was the Board of Legal Document Preparers, or the attorney that advises the board, filed a petition to change certain things about what we can and cannot do. And I had a big problem with the idea that we could create templates and do things before people came in, but not afterwards. So in other words, let's say the problem I saw with it is that, let's say that you have a template for motions to enlarge time to serve, but you haven't done one in a long time. And then, Mr. Client comes in and says, I need you to do this type of a motion for me. The way it was proposed, my understanding of what was proposed to be changed is that now that the clients come in, you can't do that kind of research to update your template. And because they're specifically so you can use your template, but and if you're like me, I'm a little neurotic about these things, and I would probably naturally want to go back and just make sure whatever I have in that template is up to date. And it seemed to imply that you could not do that by virtue of the fact that the client has now come in and asked for that document. A little weird. Anyways, hopefully that answers some things to some extent. Somebody else asked a question about whether you can cite case law. I think I would suggest that people follow whatever the board is telling you at this point. I will say that what I just described about utilizing a court rule or a statute, it is my opinion that we were always intended to allow to use primary authority just the same way as it relates to case law. Again, it's a tricky proposition about how you have that conversation with a prospective or a current client. But if you're doing a template, and let's say you're doing, I'll go to an extreme. Let's say that you have a template for a motion for summary judgment, and you've put together that template in such a way that you're citing the court rule, as well as maybe you have some of the popular common case law that you see in every, pretty much every motion for summary judgment. Is there anything wrong with that? You have a template. You're not tailoring it specifically to this particular client. It's my understanding that is an acceptable way to practice. But is that now in the eyes of the board? I don't think it is. And so, these are things that need to be really hashed out and hopefully can be hashed out with the changes that are going to be going on with the new licensing tier, and the licensing tier will probably also result in some clarifications and changes in our code. And we'll talk about that a little bit later, but hopefully that kind of answers the question in a vague way. Do I think that it was intended to be allowed? Absolutely. During our deliberations when we were putting together the code, we very clearly spoke about the idea that these type of services were being done by legal document preparers, and they should be allowed to continue to be done by document preparers going forward. And that was the intent of the code. Having said that, though, that's clearly not the opinion of the powers that be right now that are advising the Board of Legal Document Preparers. And quite frankly, I understand. If I read the code carefully, I understand where they're coming from. I see the vagueness or the problems that they have with it. But not that I or Alan or other people that were participating in that original ad hoc committee should be the ultimate authority. But, it is kind of odd to me that nobody asks us, because we were there. We're fine. Don't ask us, but ask us and ask bar members that participated in it what the original intent was, if there's a question of interpretation. And that never seems to be done. Again, I think we're kind of forced in a direction where we're going to need to really clarify these things, and hopefully they can be clarified in such a way that is in the best interest of the public, because the public, our businesses are harmed, certainly, if we cannot offer those type of services, and we're used to it. But also the public is harmed, which is what the court, I think, is concerned with, and should be concerned with. That's what they're representing that they are concerned with, that because now you have a situation where people, literally, hundreds, if not thousands of people that come to us for those type of services every year cannot access those services. And isn't that the point? So hopefully we can reach some kind of an agreement. There's a little comment here by Alan Merrill. Although I don't generally cite, Alan says, although I do not generally cite authority or case law in my documents, I believe that the administrative code does allow any or all those things. Nevertheless, if you do intend to use them, you better have the money and ability to fight the board in court. So that's I won't say that's advice by Alan, but that's Alan's thought on the matter. And yeah, it is a little odd too in some respects, because on one hand, and I've made this argument many times, on one hand, the code requires that we follow all court rules and statutes, and those rules and practices would include that if you're going to do a motion, you should cite your authority. So if we're going to do that, you would think that, and if we're allowed to prepare any legal document, then you would think that there'd be some way that we should be able to provide that type of a service. Anyways, but any other comments on that are welcome. I'm going to go on with some other parts of the of this section. So I'm down to professionalism. So legal document preparers shall treat information received from the consumer as confidential, yet recognize and acknowledge that the privilege of the privilege of attorney-client confidential communications is not extended to certain legal document preparers or to certified legal document preparers. So what does this mean? So that, that means that, everything's confidential, but we can be subpoenaed. Our work, the work product can be subpoenaed. Anything that we have can be subpoenaed. We can be hauled into court and as a witness. I'll tell you, I have personal experience with that. It hasn't happened a lot, but I probably, every couple years, I've had a subpoena ducis tecum sent to me about a particular matter. Often it's either a probate or not a probate, but an estate planning or a divorce-related matter. And I have been subpoenaed to court to testify on 2 or 3 occasions having to do with probate / estate planning matter. In other words, like a will that I prepared for somebody, and I've never had really an issue with it. But I think it presents a serious dilemma for us because we are required to keep good records, and I may get this wrong. I think the rule is we're supposed to keep them for 3 years, so now what's the purpose of keeping those records? The purpose is so the records are there for our clients. At least this is my general understanding of this rule, and I'm sure there's more to it. But it's there for the clients, so the clients have access to those things. But the dilemma comes up is that, okay, if I know that I can be subpoenaed, I know that an attorney that represents the adverse client from somebody that I've been doing work for can get all my notes, all my, the questionnaires, the, whatever it is that I've prepared, does that put our client potentially in some type of jeopardy? Particularly if, let's say, I prepared something, I don't know what it is, let's say it's a civil matter or a family court matter, or a probate matter, and the client has given me copies of a bunch of things to just kind of to go over with me. It had always been my practice to make sure I gave these things back to the client, and I would ask the client, what do you want out of this file? It's your stuff. I have this file. I can be subpoenaed, for this information. What do you want back? And I don't know if a lot of that same information is protected at all anyway. But I don't want to be the one that has this stuff that ends up creating my client a problem. I'll self-disclose a little. I had an issue a number of years ago in a civil matter where there was a complaint filed by the attorney for the adverse side, just kind of complaining about, and I'm not patting myself on the back. This is truly what it was about, complaining about how good the documents were that I prepared for this person. Without getting into detail on it, during the investigation, the investigator was not too happy with me that I did not have hardly any documents on the matter from the client, or because I gave them back to the client, and so he let me know that I should keep my records, and I did have my records, my basic records. But he was wanting to see through the client's notes and lots of other things, and I did not have them anymore because I give them back. So I don't know if any of you have any experience with that or comments on that, but these are things. I'm presenting this as just something to think about. So to kind of move on, document preparers should be truthful and accurate in advertising. We've kind of talked about that. Legal documents shall maintain and observe the highest standards of integrity and truthfulness in all professional dealings. That those relate to what we've been talking about. Document preparers shall keep abreast of current developments in the law as they relate to legal document preparation, and shall fulfill ongoing training requirements to maintain professionalism and the skills necessary to perform their duties competently. So that's why we're all here today, right? We're refining those skills, keeping up to date on things. Fees and service. Legal documents shall, upon request of a consumer at any time, disclose in writing an itemization of rates and charges to the consumer. Pretty straightforward. As you all know, we determine our fees independently, except as otherwise established by law. Entering into no unlawful agreements with other legal document preparers on fees charged to any consumer. So The only other place that I'm aware of right now, and maybe somebody can correct me if I get this wrong, but bankruptcies. If we're preparing bankruptcies, there's a local rule that requires we can't charge more than $200. But other than that, I think we can set our own fees. Legal document preparers shall at all times be aware of and avoid impropriety or the appearance of impropriety and as it relates to fees, like by establishing contingency fees as a basis of compensation, directly or indirectly receiving any gift, incentive, reward, or anything of value as a condition of performance of professional services. So these are, so I don't hear about, I haven't seen any complaints lately, and maybe I missed them, but I haven't seen any complaints lately about these types of topics. Back when the program was just getting off, I think there were a lot of independent paralegals and some of which became CLDPs that were negotiating personal injury claims, charging contingency fees. And this was a time that I was on the board. I mentioned this at the beginning of the seminar. I was on the original board of legal document preparers, and so we saw quite a few of those issues that came up. Again, I don't think hardly any of them were consumer-related complaints. I think they were just I think there were attorneys that somehow found out about these things. And then we have skills and practices, performing in accordance with the law. These are all, issues. I'm gonna kind of move on in the interest of time. I talk a little bit too much. So back to the screen. So we're gonna start talking about complaints. So when should a document preparer worry about a complaint? So when the LDP's roles and responsibilities are not offered and or performed consistent with the LDP code of conduct, that's when you should worry about a complaint. So it's a good general statement. So filing complaint, who can file a complaint, and should you file a complaint against an LDP? So all judicial officers, court employees, certificate holders shall, and any person may, file a complaint. Also, the division director of certification and licensing of AOC has the ability to file complaints against us, so they can initiate their own complaint. Now, what does that look like? This is what you're seeing on your screen is a sample of it's what they have on the court website, the complaint form. And as you can see, it's a general form that's used for all the different certification or licensing programs that the court currently manages. There's a place for LDPs, and then it just goes through asking questions about why you're filing the complaint, providing the complainant's information, what happened. It's a pretty general form. It does give some instructions about the process, about what will happen. And let's see if I can, from my perspective, I can't see it very well. Well, I'll go back to, let's see.
Control plus.
Okay. All right. So, anyways, you can all see, and maybe you've had some experience with some of these seeing, but we'll go through it in just the regular course of the presentation. So this is just to show you an example of what's online that consumers can access. So next we have the complaint. So the complaint contents. The complaint shall be in writing with sufficient specificity to warrant further investigation. So how specific? To survive the initial screening process that the court does, it has to contain specific information to permit an investigation. It must provide specific allegations of acts of misconduct or violations of the statutes, court rules in the section or applicable to a section of the ACJA. Specific means clearly defined or identified in precise detail. I hope this is followed. I've had, the one experience that I was kind of alluding to earlier is a situation that I didn't believe that this was filed and followed this, because just to say that your documents, couldn't have been prepared without giving legal advice is kind of a general statement. Now, maybe there's, I'm not saying that the program needs to be stupid about it and not see what's evident. But the bottom line is that the complainant needs to provide some factual allegation that shows, that indicates what you've done wrong as it relates to the rules or statutes or the ACJA. What if the complaint is not specific? So if it's not specific enough, the division staff shall recommend that the division director dismiss the complaint. Other minimum requirements, they have to provide their name, telephone number, and address of the complaint. Used to be at the beginning of the program, people could file anonymous complaints, but they can't do that anymore. At least I believe I'm right about that. What's the role of the division staff? They determine jurisdiction. So what would be a jurisdiction? Jurisdictional issue might be, something you did in another state. The court doesn't have jurisdiction to deal with here. They have to determine whether there's sufficient information to permit investigation. They have to verify the details in the allegations. And the details have to be corroborated by independent observation and information, the allegations of acts of misconduct or violations of statute, court rules, or the ACJA. So what won't you get out of this? So surrendering your certification. Okay, I'm sorry. Let me rephrase that. What won't get you out of this? So in other words, you get a complaint filed against you and you just don't want to deal with it. So is there a way to not have to deal with it? Not that I'm aware of. So some people have tried to avoid the complaint process by just saying, here, look, I'm going to surrender my certification. That's not going to get you out of it. If your certification expires, likewise, it's not going to get you out of it. Non-abatement, failure to cooperate, withdrawal of the complaint. So if you have a former client that withdraws the complaint, there's a settlement or compromise between the complainant and the certificate holder, or restitution paid by the certificate holder of some site, or that's not going to get you out of it. They are still the board, the program. They are still going to continue with the investigation. Confidentiality of the complaint. It's important to know that the complaint is confidential by the director, deputy director, division, staff, the board, court employees during the course of an open investigation, except as it relates to the staff, the attorney general, the county attorney, and law enforcement and other regulatory officials if it becomes necessary for them to get involved. If the director determines disclosure is in the best interest of the public and the interest is not outweighed by any other interest, they can make the information public, I guess. And it's not contrary to the law. So they go through this investigation. Once a finding of probable cause has been entered, all information and documents are open for public inspection. Complaints dismissed by the division director for lack of jurisdiction, insufficiency of information, remain confidential and not a matter of public record for inspection. So if you get some, complaints that are a little off the wall, maybe people or organizations or who knows who that where the information is just it's not sufficient on its face, then that's not going to be a matter of public record for inspection. So reasons to dismiss the complaint after the initial screening. Again, falls outside the court's jurisdiction, doesn't provide the name of the certificate holder. Obviously, you can't process a complaint if we don't know who's being accused of it. Doesn't contain sufficient information to permit an investigation. Doesn't provide specific allegations of misconduct or violation of statutes, rules, or the ACJA. And other reasons to dismiss a complaint after the initial screening is it contains allegations of misconduct or violations that, if true, would not constitute a violation of the statutes, court rules, or the ACJA. Or again, doesn't provide the name of the complainant, doesn't warrant for further investigation or evaluation for other reasons. The investigation itself. The preliminary investigation is to determine probable cause. So typically what happens is that a notice will go out to, well, what will happen is a notice will go out to the certificate holder about the complaint. And that notice, it has to go out within 15 days of receiving the complaint or the date the director initiates the complaint if it's originated by the director. The certificate holder's response to the notification of a complaint must be in writing, must include general information about preparing must be done within 30 days of the notification, although you can request an extension and from what I've seen, that's usually granted, but depends on the circumstances. So filing complaint, you're responding to the specific allegations of complaint generally. The investigation as it continues, there are almost always interviews. From what I've heard, most of them are telephonic. And I have a note on there to be careful. Be careful because just like any similar matter, what you say can and will be used against you. And so you want to be open and honest, but at the same time, not open up issues that aren't issues. Other forms of investigation or discovery, they can request documents, they can do investigative subpoenas. When they have all this information, the investigator will do an investigation summary. And I would note that watch out for surprise facts and allegations of misconduct, particularly if the allegation is a little bit vague. But regardless, I mean, you always want to try to get a copy of that investigative summary as quickly as possible, like before before the day of that it's going before the board, because there might be some surprises in there that you haven't had an opportunity to respond to yet. So the probable cause review panelist is the deputy director. Again, on completion of the investigative summary, the findings by the probable cause evaluator and the written recommendations by the division director have to be forwarded to the board by the board's next meeting. So as soon as they're done with that summary, they have to send it to the board by the next board meeting. The board has to do one of the following. Determine the certificate holder did not commit any acts of misconduct or violations and dismiss the complaint. Determine the allegations of the acts of misconduct do not warrant discipline, but actions need modification or elimination, and send an advisory letter to the certificate holder. So that's just a letter just saying what I read. It's not, they're concerned, but I don't even, concerned is actually the next level. But determine the allegations of acts of misconduct or violations may be resolved through informal disciplinary proceedings. Informal might be a letter of concern. Determine the acts of misconduct may be resolved through a formal interview. So they might bring you down to speak with the board about what's happened. Determine the acts of misconduct or violations may be resolved through a formal disciplinary proceeding. Or finally, determine the acts of misconduct may require emergency summary suspension. Haven't heard that happen too often. Many of you might be aware, I think there's a link to a list of people that have had their certifications revoked or suspended that you can look at. Okay, so because I'm running out of time here, I'm going to move on to some information I have that you may want to consider about protecting yourself from an event of an investigation, or at least protecting yourself during that process. And I think as I talk about this, it'll become a little more clear. Three ways that I've cited here, and that having to do with contracts that you have with your clients. In my experience and talking to a lot of document preparers out there, often they do not have written contracts with clients. Having a system in your practice. So in other words, a way of doing things that and so that you can show, or at least you have evidence that if a complainant talks about you being inappropriate or not doing things in a particular way, you have a way of demonstrating the system that you have. And I'll talk about that more in a second. And then finally, just a little note that the customer is always right. And what I mean by that, in past meetings, we've talked about this, the idea that a lot of times, even if you don't feel that you did anything wrong, you think you're perfectly justified in what you've done. Your documents are completely appropriate and well done. Yet you have this customer complaint that has maybe not gone to the board yet. I know a lot of people's practice is to do what the customer wants. If they want a refund, they want to cancel the service, it's a lot less of a hassle, and it ends up being a lot less expensive to maybe deal with the customer prior to it getting to a point where they're filing a complaint. Again, this is a judgment call by people, but I think it's probably a good policy in many respects, because going through this process that I've just described is not a simple matter. Contracts with clients. So this is an example of a contract that you might have. It has the notice in there. This is a pretty basic example, but it has all the notice, the information that we're required to disclose as certified legal document preparers. And so you may want to look at this on your own time to see about the different elements that are in here. But it just makes it clear, and I know this comes up that probably the most important parts of this are that you're not representing your attorney. You're making very, very clear that you're not an attorney. You don't work for an attorney. There's no attorneys associated with this firm, and also that you're not giving specific legal advice. But I've had my own versions of this contract that are much more extensive, and I might even say a little bit obnoxious. But for the most part, I don't think I've ever had a client not sign the contract. And if they won't sign the contract, then maybe you shouldn't consider doing business with them, because maybe that's a red flag. Having a system in your practice. So a system of the way that you do your phone consultations, your own little spiel about how you talk about what you do, what you can do, what you can't do, the way you give fee quotes and tell people about your fee schedules, using questionnaires to gather information. Now, this can be extremely important because and I've seen this happen many times in complaints, where there's information in there that there's information missing. Let's talk about, for way of example, a divorce. a lot of people, for whatever reason, are very resistant about itemizing how they're dividing up their assets and liabilities. And so if that poses a problem for them, as sometimes it does down the road, even after the divorce is final, at least you have some kind of evidence that shows, hey, this is filled out in their handwriting, this is what they gave me, and this is what I put into the documents. So you're not just stuck with a he said, she said kind of thing about what information you're told by the client to put into whatever legal document you're preparing for them. That goes for everything, anything that you do, really, whether it's a probate matter, an estate planning matter can be extremely important. Let them fill out a questionnaire. Let them provide you with, the information that you need to prepare the documents. Have it come directly from them. Have a way of documenting that. Keeping completion deadlines. Obviously, that's a potentially big source of complaints. You miss a deadline that you've committed to. I'll stick with the divorce process. You've taken on the responsibility of calling the client and telling them when it's time to sign and file their application for entry of default, or it's time for them to call and schedule a default hearing or come in and sign a consent decree, whatever the case may be, and you don't keep track of that. And you call them 6 months afterwards. Or maybe you just don't contact people when the documents are ready. You want to keep those completion deadlines, so when problems come up, you have a way of documenting that that's not your doing. Another good example, something I've seen happen a couple times, where I prepared a divorce for somebody. We had a deadline to get the divorce done. It was done, contacted the client, left the messages, documented that. And lo and behold, they don't show up for a month. And in the interim, their current spouse, ex-spouse to be, takes out some big loan or gets in a car accident or something like that. So you've not started that process. And so there's issues about, that are related to those things. That's just an example. But keeping completion deadlines are so important for lots of reasons and can really get you in trouble. Having a review procedure. So, when a client comes in to sign their documents, we sit them down. We sit them down at the
Unknown
table.
participant is now joining.
We give them a pen. We give them a pen, and we give them stickies, and say, use these stickies to tag anything that is incorrect. If there are typos, if there are just inaccuracies. Going through, having a process that you can just describe to an investigator about the way you do things. Document approvals. I've run into very few document preparers that use these, but I think it's advisable.
Unknown participant is now exiting.
To have a document approval, a simple form that just says something to the effect, I've reviewed the documents and I approve them the way they are, even if they differ from any written instructions that I've given you in the past, and then just kind of repeating, the client understands that I'm not an attorney and no attorneys work there. So, I think it can only be helpful to get a little obnoxious about some of these things. Again, when I was in practice, we used these for 25 years, never had somebody that wouldn't sign it. I'll tell you what other benefit it has is that, and I'm sure many of you have experienced this, is that clients don't want to review the documents, especially they like you, they have great trust in you, and they're just like, yeah, I'll sign it. Well, when you stick a document approval in front of them, a lot of times they'll rethink that and go back and look at the documents a little more carefully. And then again, having follow-up procedures about whatever process that you're engaged in. This is an example of a document approval that I've used in the past. And so, it has the information that I've just kind of cited. Excuse me. I strongly recommend that you use something like this. So, all right. So we're at the point where we're going to talk about the program update. And so I have somebody that's going to help me go online. so we can look at this. So just to kind of set this up, and we're just going to spend a couple minutes on this and then take our break. Here we are. All right. So many of you are aware that there's been a task force that met over the course of about a year, talking about other ways that the court wants to promote access to justice to people that cannot afford to hire an attorney, and they talked about many reasons why attorneys aren't serving people in the middle to lower income strata. And so we've been talking about our last couple seminars we gave. We talk about how this is something. One of the many recommendations of this task force was to create the limited licensed legal practitioner. And just so you know, that the court has submitted a rules change petition, a Rule 31 change petition to add limited licensed legal practitioners, and they have also submitted a proposed amendment to the ACJA that details. That provides some of the details, basically similar to our 7-208. This would be under section 7-210, entitled Limited License Practitioners. And I'm going to briefly go over some of those details. Before we do that, I want to play a little video that they already have up about this. If you would, it's just a short video to describe what they're promoting. Hopefully you can hear it. I can't hear the video from where I'm at, but hopefully the rest of you can.
You can unmute your speaker. No, you can unmute your speaker.
Oh, okay.
Yeah, I wouldn't know that. I don't know if you should do that though.
So you think everybody else can hear it?
Yeah, I just
No, we can't hear it.
Nobody can hear it?
No, I can't hear.
No.
Cannot hear
Okay.
it, John.
All right, I got the message. Well, as you see on the slide, there's a link that you can go, and I just wanted to encourage everybody to look at the information that's on that link, and that's the link again is www.azcourts.gov/access to legal services. And if you go on there, there's a whole bunch of information about where you can access the rules change petition for the Rule 31. There's two separate petitions, one of them to modify Rule 31, one of them to modify the ACJA to add this 7-210 limited licensed legal practitioner. And just to kind of go over that with you, it's set up very similar to our code, and there'll be a board appointed. Again, interestingly, the board will have 2 certified legal document preparers, 2 limited licensed legal practitioners, a judge or court administrator, a clerk of the court, or a designee, an attorney, 2 public members, and 2 additional members to be appointed by the Chief Justice. So it'll have an 11-member board. The licensure requirements, the eligibility, just to briefly go over that, they're going to have an exam that you pass, and the exam doesn't, it's yet to be determined. It will be established by the board, but the exam doesn't seem to be that it will be that challenging necessarily, but a major difference is the qualifications as it relates to education. And so just for individual licensing, same as what we have now, you have to be a citizen of the United States, at least 21 years of age, not been disbarred, of good moral character, somebody that complies with the laws, rules, orders adopted by the Supreme Court, and the applicant, and here's the important part that I want to emphasize, the applicant has to successfully pass the limited license legal document examination. And I'm sorry, this is the part I want to emphasize. The applicant shall also possess one of the following combinations of education or experience. So A, they all have to have a 4-year Bachelor's of Arts degree or Bachelor of Science degree from an accredited college or university in any subject, and the following. So in addition to your 4-year degree, you have to either have one of the following. One would be an Associate of Arts degree in Paralegal Studies from a college approved by the court. Another, or a post-bachelor's certificate in Paralegal Studies from a college approved by the court, or has completed any certification program for limited licensed legal practitioners approved by the court. Before I say the I want to mention that I saw on the internet yesterday, and I don't know anything about the program yet, but I saw a story about the U of A apparently is developing a program, a special program for limited licensed legal practitioners that supposedly will start in operation in the fall. So that's interesting. I'll try to keep people updated on what else I find out about that. But okay, so again, the third edition is the completion of any certification program for limited licensed legal practitioners, and then it gives a breakdown of what has to be included in that program. So so if you want the family law and civil practice endorsement, which I haven't talked about that yet, but there's basically going to be different endorsements that you can get as an LLP. You can be endorsed to practice family and civil law, or criminal law, or administrative law. Let's see. I think that's it for now. So it breaks down different credit hours that you have to have in that education in each of those areas. I won't go into all those. And then it just talks about the roles and responsibilities. It talks about preparing and signing legal documents. So that someone with this license will be able to prepare and sign legal documents, provide specific advice, opinions, or recommendations about possible legal rights, remedies, defenses, options, and strategies, draft and file documents, appear before courts or tribunals on behalf of the party, negotiate on behalf of clients. So without going into a lot of detail, this is a big jump from what we've been doing. It includes what we've been doing, but that it's a big jump to provide closer to what I would refer to as attorney type services. So anyways, my point in this section is that I wanted to just alert you to where it's at, where you can get and read information about it. You can comment, and it tells you on this page how to comment on the different proposals, whether you're for it or against it, or if you'd like to see it modified in any ways. So any questions about that section? Trying to see if I have any. Let's see. Okay, so I'm not seeing any other questions. So lastly, and then we're gonna take a quick break and go on to the next one. Is Rob Merrill one of the attendees? And Rob, if you would turn on your mic. And I'm not getting a response back from Rob. So
can you hear me, Don?
Yes. Okay. So before you start, Rob, I just wanted to say, with everything that's going on with the health crisis that we're all going through and the economic crisis that we're all going through, and I'm aware that yesterday the Congress passed the kind of the relief package. I wanted to, best that I could in such a limited time, I wanted to ask somebody to come in and comment about maybe where those of you that maybe are struggling because of what's been going on in the economy, there's a lot that's going on with the Small Business Administration, possible access to funds that you can get to keep your business going, keep your employees employed. And I wanted to take just no more than 5 minutes to have Rob. And Rob, you can briefly talk about your little background as to why I asked you to comment on this, just so to give people kind of a starting point to look at. So hopefully everybody doesn't mind to spend a couple minutes on this. But Rob, go ahead.
Thanks, Don. I'm having a little bit of an issue with my camera, so I'm gonna stay audio. But so for those of you who don't know me, I spent 12 years in banking, 7 of those as a bank manager for BMO Harris Bank. And part of my responsibilities in the 9 years that I was with BMO Harris was SBA and small business lending. And so I've done dozens of small business loans and SBA loans, and so I'm pretty familiar with the ins and outs. Now, some of that may have changed in the last 6 years or so, but for the most part, this is what we're looking at. Now, keep in mind, there's not a lot of detail on this. This bill is about 12 hours old, or this law is about 12 hours old, so we don't have all of the details, but I want to give you some just general information about how SBA lending works and some of the things they're typically looking for so that you can be prepared if you decide to take advantage of this, which I think would be extremely highly advantageous to everyone. Generally, this is what is out there now, and this is coming from from Forbes, an article that they've posted this morning. And basically, these loans are going to be available to small businesses that are under 500 employees, so everybody but Don. And then the loan payments are going to be deferred for 1 year. They're going to be low interest loans. I did talk to a friend of mine who's an SBA lender, and they said that they think these loans are going to be somewhere between 2 and 3.5% interest. And they're available to self-employed individuals, independent contractors, sole proprietors, everybody. Generally, what they're looking for in terms of a loan amount is 2.5 times the monthly operating costs of the business. And that's fairly vague, but generally what that includes is going to be employee payroll. I'm assuming payroll to outside contractors, employee health care, mortgage, rent, utilities, debt payments.
Hayden is now
supplies,
exiting.
office supplies, all that kind of stuff. Some of the things that are a little different from SBA loans are that they're in order to facilitate the faster transfer of these or faster completion of these loans, they are going to do away with personal guarantees on them. I'm sure there is going to be a dollar to that. Generally, these emergency loans are usually $25,000 is the maximum on them without a personal guarantee. Just in general, they don't happen hardly ever. But my own personal opinion and assumption would be that there would be some limit on those. So that gives you a little bit of an idea of what they're looking at. Now, just in my experience with SBA lending, their documentation requirements are usually fairly stringent in this fact that you can't just show up and say, well, this is what I need. You're going to have some sort of documentation, and whether that's a profit and loss
is now joining.
statement. Well, this is what I would have prepared if you were planning on pursuing one of these loans. I would have a profit and loss statement put together, whether that's QuickBooks or whatever accounting software you have, or something on a spreadsheet that's very detailed as to your expenses for the last year or last 3 months or whatever they're going to require. I would also have a payroll summary put together of what your payroll costs have been for the last 3 months to a year. If you use QuickBooks religiously like I do, that's very easy to do. And the last thing is put together a balance sheet of if your company has a balance sheet, or a balance sheet for yourself personally if they ask for it. Whether or not they're going to require this stuff, I don't know. But generally, this is what they ask for, and so it would not surprise me at all if they required this type of documentation. The other thing that I will say is, for those of you who maybe aren't accounting majors or CPAs, that when you do generate these documents, be sure to generate them on a cash basis. So if you use QuickBooks, when you generate the report, there's a at the top left-hand corner of the report, there's a little radio button that says accrual or cash. Make sure you click cash, because if you do it on accrual, the report's going to be wrong. And so, so yeah, just some thoughts on that. Certainly something that would be advantageous, something I would talk to your bank about. I'm suspecting that these will probably be done through SBA preferred lenders. An SBA preferred lender is just a lender that is able to produce a loan without the approval of SBA, without having to actually go to SBA and get approval to make the loan. Every major bank, Bank of America, Wells Fargo, Chase, BMO Harris, I know is one. Most major institutions are SBA lenders. I don't know if some of the smaller banks or credit unions. So, but we'll see. The details on this are going to come out over the next couple of weeks. So just keep checking out for that. And if I find any information, I can forward that on to Don.
Okay. All right. Thank you so much, Rob. And Rob, are there any particular banks that would be maybe better to call if, Monday I want to get going on something like this? Any particular banks that would assist people with things like this that'd be better to call?
I'm not sure that there's one better than the other. I mean, generally, if you're with a major institution, you're probably, anyone at your bank is going to be able to do that. Any of the major banks, the three big banks, are going to probably refer you to an 800 number, and to kind of give you information on this. However, they have not given the direction to the SBA on this yet. That's one thing that was pretty clear in a press conference on Thursday, was that those rules are kind of pending to go out to the SBA. The idea being that the kind of the rules and guidelines of these loans, and so that they are very clear, very simple, so that they can actually disperse the loan the same day of the application. So, which is, if you've ever done an SBA loan, that doesn't ever happen, ever. And so they're serious about this, but I just don't know the details on that. But any major institution, as long as you're not banking with, Podunk Bank in Yuma or something like that, then you're probably okay.
Okay. And then one question I see is that are these loans different from the SBA disaster relief loans that people have already been applying for because of COVID-19?
I don't know the details on that. It sounds, I know those disaster relief loans, they're really not that easy to get. And I suspect that those are either that's going to fall under that category, or they're going to be modified in some way so that they're a little bit simpler to get the process rolling.
Okay.
Those loans generally take some time. And so this doesn't sound like that. So. Okay.
All right. Well, I appreciate it very much, Rob. And so we are now going to, I think, go to taking a break. We're going to take a 5-minute to set up for the next presenter. And then also when we come back from the break, the first thing I'll do is give you that next magic word for verification. So go ahead and take a 5-minute break and we'll be right back. Okay. All right. So we're going to move on to the last leg of our great presentation today. And I'm going to introduce Carol Montgomery, and she'll tell you, she's going to talk about all text and many other things related. So let's welcome Carol Montgomery.
Thank you, everyone. All right, so I'm going to start my timer just so that I don't forget that I have to settle down and stop and make some changes. So my name is Carol Aragon Montgomery, and I have been a certified legal document preparer since 2003. Today we are going to have two parts of our conversation, and the first part is going to be about government benefits and some of the legal documents that are associated with those programs. And then we'll take a little break, and then I'll start a second part of my program, which is growing and protecting your certified legal document preparer business. So kind of bear with me through that. Many of you have seen me before, so you know me. I have a lot of information to pass on to you. I did send out my handouts ahead of time, so Don sent those to you. So pretty much if you follow the handouts, don't worry about necessarily what's on the screen. I just wanted to have a visual to go along with my talking. But the handouts that I provided to you, of course, are going to have all of the information as well, and probably a little bit more. My career basically started as working at the Altex program. So that's where I started almost 30 years ago. I was actually an employee of Access. And then 5 years into that, I decided to leave state service because I got married and I wanted to be a stay-at-home mom. And I was headhunted by a law firm not very long after I left state service to kind of come in and help build their elder law department and their Altex planning department. So that's a little bit about kind of where I started. After working there for about 4 or 5 years, I just saw that there was a need for my services for kind of the interim client, right? So not everybody can afford a law firm, and not everybody can do it by themselves. So as a independent person, I went out and started my own business. So for 30 years, been in the long-term care planning field, and then for the past 20 years have owned my own company, Montgomery and Associates. Obviously, when the Certified Legal Document Preparer program came into play, since I was already doing legal documents as an independent paralegal, I, of course, did the certification and started that business at that time. And then in 2014, we decided, because we were getting lots and lots of questions about the Medicare insurance side of things, not only Medicaid, but Medicare, we decided to become insurance agents and licensed and appointed to sell and deal with the Medicare insurance side of things. So been at this a long, long time. And over the years, obviously, when you're in business for yourself, you get lots of questions, lots of people asking things. And I just want you to know I'm always available. I always want to make sure that the information that I'm sharing with you is valuable to you. And so obviously, if you have questions, please make sure that you're putting them into the chat so that I can answer them. Again, I have lots and lots of information. That's just my personality. I'm a let's get you educated, let's get you evaluated, and let's provide you with your options. I think it goes really well with what we do as a CLDP group. We are all about educating our consumers, evaluating their option, evaluating their situation, and then presenting their options to them. So I think that flows really, really well. So let me get started with the Altex side of things. Again, we'll be talking through the eligibility. I want to progress fairly quickly through this because I have so much information I want to share with you today, and I'm really excited about adding the CLDP business information to you as well. So on the federal level, there are 2 insurance programs. Of course, the Medicare program that exists. That's the entitlement program that you pay into during your working career. And Medicare itself has 4 separate parts. It has A, B, C, and D. Medicare is not a long-term care program, though. It only primarily covers the acute care services, and that's going to be things like doctors, hospitalization, lab work, x-rays, things of that nature. And long-term care side of things is only really going to cover about 20 days for rehab. If you're making progress, then you can get up to 100 days, but you're not guaranteed that 100 days. And that's really important, especially if you're working with long-term care types of clients and individuals. They really need to understand that, because Medicare is not a be-all, end-all. It's just a program that's supposed to be there to help people cover medical expenses when they're age 65 plus, or when they've been on Social Security disability for 2 years. Then those individuals are also entitled to Medicare. The second level of insurance programs is Medicaid. And in other states, most of the other states, they refer to their program as Medicaid. But in Arizona, we don't cover, or we don't call it that. I mean, it is part of the program, but it's referred to as Access here. So Medicaid itself, the regular Medicaid programs do not cover long-term care either. They're not an entitlement program. No one is entitled to receive that coverage. It's a needs-based program that one must qualify for. And it's also known as Title 19. And then each of the states were given an opportunity to create their own program. Of course, Arizona called theirs Access, which stands for Arizona Healthcare Cost Containment System. And I think in the name, it kind of tells you what their goal was, right? To control or to contain the cost of healthcare in the state of Arizona. So Arizona operates on a very different model than most of the country's Medicaid programs. We operate on what's called a capitated model, which means that every person that's on the program, there's a capitation or an amount paid to the provider or the health plan that helps cover that member's benefits. And they're paid for that member every single month they're on the program, whether or not they use the services, okay? So in a fee-for-service model, then the payments aren't paid until the actual service is incurred. So that's going to be a little bit different for Arizona because they pay out every single month whether or not you use the program. The specific Medicaid program inside the state of Arizona, also part of the Access program, is that pays for long-term care, is going to be the ALTEX program. It stands for Arizona Long-Term Care System, again, is a division of the Access program, and it is the Medicaid program that is specifically designed for long-term care. In order to qualify for that program, though, a person has to meet 3 sets of eligibility criteria, and there is a 45-day processing time frame. So the first set of the criteria is going to be what we call the non-financial side of things. Again, I'm not going to go into every single one of these just because for timing purposes, I want to make sure that we stay on track here. And so in terms of eligibility for non-financial, it'll be these things that are kind of listed on your screen. Marital status is probably the most important on this screen in that if you are a married person, the rules are going to be a little bit different for you than for a single person. And then the approvable setting is very critically important because a person has to be either living at home in a 24/7 care setting and cannot, of course, be residing in a jail or a prison. Potential benefits is critically important to ALTEX as well, because if a person has any potential benefits, they are required to apply for those benefits. They don't have to actually finish the process for those applications in terms of submitting everything and getting everything into the entity, but they have to start the process, whatever the beginning stage of process of that is. So for example, for the Veterans Benefits Program, you have to basic application to at least get the process started, even though it might take 6 or 12 months to process that eligibility. That's not going to hold up your application. It'll just be that you have to start that process. And then third-party liability is just where you have other sources that would be paying for that long-term care or for the acute care. You do have to assign those benefits over to the state of Arizona so that they can bill those other entities and be the payer of last resort. Obviously, they don't want to pay any bills that they are not responsible to pay. The next set of criteria that's important is the medical guidelines. And I always like to refer to this section kind of using the screen there. And that is you either have to be severely cognitively impaired to qualify for the program, or you have to be severely physically impaired, or you have to have some combination of the two of those things. Cognitive impairment is going to be those things like dementia or Alzheimer's or a Parkinson's with an Alzheimer's diagnosis or a Parkinson's with a dementia, vascular dementia, things of that nature that are impeding your ability for self-care where you just personally can't remember or you need to be prompted to do those kinds of things. On the severely physically impaired, that's going to be more on the side of like traumatic brain injuries or people who have a disability that impacted their ability to use their arms and legs. And then, of course, a combination of those two. In your packet, it does talk a little bit more in detail about what Medicaid is looking for there. So obviously you have to score at least 60 points to qualify for that program. So that doesn't mean that just anybody who wants to be on this long-term care program can be, even if they meet all of the other non-financial and financial criteria, they still have to meet the medical component as well. And this is an area that actually has gotten a little tougher in the last few years because Medicaid obviously spends a lot more money on their long-term care program than they do on their acute care program. The capitation is much higher. It's between $3,000 to $6,000 depending on other circumstances. So it's a lot of money that goes out and they want to make sure you actually need the program and are going to use the program. So there are some things in your packet that talk about, requiring medical monitoring, whether or not you have that Alzheimer's disease or dementia diagnosis, being able to control your bowel or bladder, at risk of needing a skilled level of nursing care. So does that mean you need to be in a skilled nursing facility? No, you do not. You can be living out in the community, in your own home, in assisted living, in a care home or a group home, something of that nature, and they can evaluate whether or not you're at risk of needing skilled nursing care. So you have to need the care and supervision of another person. You need to be in a situation where maybe you have difficulty communicating with people or communicating your needs. So those are all the kinds of areas that they're looking at. If you come into the program and you say, hey, I have my mom or dad or my grandparents have a dementia diagnosis, you're going to need to take that to the next level. You will actually have to have them be seen by a neurologist and have a neurological review of their situation to see if a neurologist is going to actually diagnose them with dementia, cognitive impairment, or Alzheimer's. Okay, so that's a critical component. The other thing that I like to mention here on the medical side of things is that if you have a person that you're caring for, a loved one, a family member, a spouse, parents, whatever, start a journal. You know, one of the things as a certified legal document preparer that you're good at is documenting, right? We are all really good at that. And so we just say, take that to that same level if you're caring for another person, because you don't realize how much time and effort you're putting into caring for that loved one until you start documenting it and start notating how many hours a day you're helping with things like bathing, dressing, toileting, mobility, transferring, eating, all of those kinds of things. Okay. All right. So let's continue on. The next area that we're going to talk about is the financial side of things. And with all eligibility programs, there typically are going to be financial things that need to be looked at. With Altex, there are three. Okay. The first area is income. Income is anything that can be received, of course, to obtain food, clothing, or shelter. And it's anything they're receiving on a regular basis that helps them pay their bills. Typically, when we're dealing with long-term care patients, we're generally talking about people who are elderly or physically disabled. So a lot of those individuals have pensions, Social Security, retirement, disability, long-term care disability, long-term care insurance policies, things of that nature. In order to qualify for the Altex program, the current income limit is $2,349. That's for a single individual, and for a couple, it is twice that. So it's $4,698 per month. If a person has income that is over that limit, the initial reaction from Altex is that you will be denied. And Altex is taking the stance at this time that they want to process their applications timely. And so if they do a computer match before your appointment and they see that you're over that income limit, many times the minute you have your interview, whether it's face-to-face or by phone, they will deny that initial application and you will have to start over again. So it's really important when individuals are going through this process that they do seek some information out, because if you understand how the process works, you understand the things that you need to do, then hopefully you can use those things to your advantage and stop them from just denying you outright. If a person is over the income limit for the program, they can use what's known as an income-only trust. It's also known as a Miller Trust. It's also known as a income cap trust. There are a lot of different names for it. And an income-only trust will help you qualify income-wise for the program. So that is something that we do and we work at and we've done a long time. I know many of you have software that also has that included in it as well. But there's just a lot of nuances to that. So just make sure you understand what that is so that you're doing things the proper way for your clients. Okay, the next area is going to be resources, and resources are anything that can be used for obtaining food, clothing, shelter, medical care, any of those kinds of things. It can be cash-related assets, it can be financial accounts, real property, personal property, anything that you can tap into to access to get to help pay for your care. And that includes any whole life policies or any life insurance policies that have cash value or that you can access for cash. So keep that in mind if you're personally trying to go through this, or if you're helping customers that are relating to this. The current asset limit or the resource limit for the LTEX program is $2,000 for a single person. So obviously that's a very low threshold for individuals to qualify for that program. So you might need to do some planning. You might need to do some spend down to qualify. For a married couple, the initial resource test is $27,728. Now that's just a baseline criteria. So that's the first thing that Alltex is looking at to say, hey, are your resources above that or below that? Okay. So if they are above that, does that mean that that person is going to have to spend down to below $27,000 to qualify for the program? Well, it depends. Some families do have to spend down to below 27, and others can get to keep as much as 128,000. There's a whole calculation that goes into that, and so obviously we don't have time to go into all of that today. Suffice it to say that that might be a good referral for me or for other people who do the kind of work that I do to help people understand and navigate that resource eligibility. Now, that being said, that doesn't mean that Alltex counts every single thing. They do have some excluded resources, but again, some of those are always excluded and some of them are conditionally excluded. So for example, the thing that comes up most often in my legal document preparer practice is people will come to me to take their house out of their trust because they're trying to qualify for Alltex. Why? Why do they do that? Well, it's because Alltex counts the house when it's in a trust, the equity value when it's in the trust. So if a person has a house in a trust and that amount when added with the other resources kicks them over the resource limit, sometimes taking the house out of the trust is the right thing to do to get them resource qualified for the program. Now, do I tell people automatically take that house out of the trust? No, not necessarily. You really need to understand Alltex eligibility and the criteria, because if you take a house out of a trust prematurely, you can actually cause them to have additional spend down. Recently, I had a person who went to a law firm first, and the law firm said, yep, the house is a counted asset, let's take it out and it'll be excluded, which was true. That was the right information at that point. But without understanding the whole picture, they took the house out prematurely. And so when Alltex calculated the eligibility, the house was excluded rather than counted, and it reduced the amount that the community spouse got to keep. And they ended up having to spend half of their cash assets in addition to removing the house from the trust. As you can see, this could be a very crazy situation, and if you don't have the right information as a certified document preparer, if you're just willy-nilly doing stuff without understanding the consequences, sometimes that could put you in a precarious situation, as it did with this law firm. Obviously, that family wasn't very happy that they had taken the house out prematurely. So just a couple of things, words of caution there if you are handling those kinds of things. Typically, a car is also excluded as long as it's one vehicle that's being used for daily activity or medical treatment. Life insurance with a face value of $1,500 or less is typically excluded. Burial plots, burial plans can be conditionally excluded as well. Again, there are caveats to everything. Alltex policy manual, if you were to print it out, is well over 1,000 pages of policy, and they are constantly adding and revamping at all times. So you do not want to just take anything lightly. Yes, you can give people some general information about that, but you wouldn't necessarily be able to say, yes, you're good to go, or no, you're not, without understanding the conditions that surround those exclusions. The third area that we are looking at is transfers. And as many of you are aware, you've probably heard this through the grapevine out there, there is a Medicaid look-back period. Back in the old days, it was about 3 years. It was 36 months was the look back period. Back in 2010, they actually changed that law and made it a 5-year look back period. So when Alltex is evaluating whether or not somebody qualifies for the program today, they are looking at, in the last 5 years, have you sold, traded, transferred, or given away money, vehicles, or property that you could have used to pay for your care? If you did and you didn't receive full compensation for that transfer, then you might cause yourself to be ineligible for the program because you could have used those assets to sell, trade, or transfer to convert to cash for you so that you could spend down those assets. Now, this becomes a really interesting place as document preparers in terms of planning, because if you're doing some type of estate planning, or if you know a person has a diagnosis early, then sometimes there could be some planning put in place 5 years in advance to protect those assets so that they don't have to be spent down. But again, that can be a precarious ball of worms. I don't know what's a good thing to use there, but that whole piece there's just a lot of information that goes into that. And depending on what you do to transfer assets, whether you use irrevocable trust or just transfer monies to kids directly, or whatever it is that people like to do out there, you have to be careful, because you don't want to take money away from a customer that could have been used to pay for their care, or put it in the hands of somebody that is not going to make the right decisions for them. So a lot goes into that kind of planning in advance. Now, I do want to point out here that Medicaid has now subscribed to a new system where their computer goes out and searches financial information out there through these secure systems. And what is happening is when people are applying for the program, they are coming into it with all kinds of new questions. So for example, I had a client that came to me. They said, hey, I don't have any money left. I need to apply. They decided they wanted my help to navigate through that. And in the process, even though I did my thorough 5-year review of them, there were things that I couldn't possibly know, nor could the kids have known, because they weren't managing mom's assets 5 years ago. And so when I applied for the program, Altex threw this list of 17 things at me that had happened in the last 5 years, that I then had to go back and literally pull every single bank statement, every investment account statement, every document relating to their situation to find all these transactions and explain why money came in, why money went out, any large monies that were moved around in the last 5 years. Obviously, I do a lot of background research when I'm working with my clients, but again, prior to this, they weren't really asking us for 5 years worth of bank statements. Now, I pretty much have to ask everybody to provide that so that I can begin to look through things and make sure that I'm looking for any flags, anything that might get red flagged by Altex, so that I can be prepared to answer any of those questions. So this is an area that they've gotten really strict on. I just want to make sure people are aware of that. Now, let's say that they did give away money, and let's just use $15,000 as an example. So people will say to me, well, $15,000 is the gift tax excluded gift amount that you can give that doesn't have to be disclosed to anybody. And that's true. That's an allowable amount that could be given away, up to $15,000 per year per person. However, with Medicaid, it's not an excluded transfer. They are going to count that transfer along with any other transfers that they had in the last 5 years. They're going to calculate how much you were not compensated. So if all of it was a gift, then the full $15,000 would be uncompensated. And then they would impose a penalty period based off the average private pay rate here in the state of Arizona. That number is just a little over $7,000. So in that particular case, that person would be roughly ineligible for the program for a little over 2 months. Now, what does that mean? Does that mean that they're going to just deny you and say, get out of here and come back after 2 months? No, it is not that, and you don't want to withdraw your application. You want to go through with the application as long as all of the other eligibility criteria are met and you are eligible with the exception of the transfer. Then they will impose a 2-month penalty period, or 2-point-something month penalty period on your eligibility. Now, the average processing time for Altex is at least 45 days. It can run 60 to 90 depending on the complexity of your case. So if you have a 2-month penalty period and it took them 2 months to make the decision, we're okay with that. We're typically going to be all right with having that penalty period during that application process, because you're going to have to private pay during that time anyway. Again, doesn't apply to all situations. Sometimes that gifting, you don't want to have a penalty, especially if they're in a nursing home and it's costing them $30,000 a month because they're on a ventilator. So again, just making sure you understand how all that works is going to be very critically important in making sure that whatever planning that you're doing or helping people with, you're doing in an appropriate way. Of course, Access and Alltex are not in the business of caregiving. They are just the ones that are determining eligibility, and they act as an administrator of the funds. They then contract with what they refer to as program contractors. Program contractor is just a fancy name for health plan, okay? It's very, very simple. It's just the health plan, but they call it a program contractor, and that is who they contract with to provide the long-term care services here in your particular county. So it's just really important that you understand Access is not providing the care. The program contractor is contracting with independent providers, hospitals, doctors, facilities, labs, prescriptions, all of that they're contracting with, and those people receive a capitated amount from the program contractor for whatever care that they're providing, okay? So Alltex is not going to be the one that's literally giving the money to the provider. They give it to the health plan. The health plan is the one that then gives it to the provider. In Maricopa County, there are 3 health plans, 3 program contractors. They are Mercy Care Plan, United Healthcare, and Banner University. Again, if you need to seek out any additional information on that, I'm going to refer you to the websites and the phone numbers that are on your screen, rather than spending a lot of time on that here. Okay. All right. The method of service delivery is they are going to assign a case manager, and the case manager is the one that will work with the family to facilitate the care and to start the services for the applicant. Alltex services can be received at home, meaning a caregiver can come into the home to help provide the care. It can be provided in assisted living care homes or assisted living facilities, and it can be provided in skilled nursing facilities. Okay, so Arizona does a really good job. More than 50% of the Alltex members receive care in the community rather than in a skilled nursing home. Something that I feel very proud of as an Arizona person, because that means we're doing a really good job taking care of people. All right. On the home side of things, I just wanted to point out here, the maximum is about 30 to 40 hours per week. So if that's not enough to keep them safe in their home environment, they would need to be placed into a 24/7 care facility. And again, those are listed there and on your sheet. So again, I'm just going to skip through that. If you're shopping for a care home, it's very, very important that you ask some very specific questions. You have to be living in an Alltex approvable setting in order to be approved. Again, if you're living at home, no worries, that's an approvable setting. But if you live in an adult care home or an assisted living facility or a skilled nursing facility, those particular providers do need to already be contracted with Alltex. How do you ask that question? You just ask them, are you an Alltex contracted provider? If they say yes, then the next step that you have to go to, just to cover your backside, is to ask for their Access Provider ID number. Why do I say that? Well, because I've been doing this for almost 30 years. So what have I seen? I've seen the worst case scenarios and I've seen the best case scenarios. The worst case scenario is I have a care home or a facility who tells my family, yes, we're Alltex contracted. And then we do the research and we find out, no, they're really not. But they've already moved into the care home. And now, in order to be approved for Alltex, they have to move. That's going to be difficult to put your family member through that multiple times. Okay, so just make sure, take it to that next level. Ask those additional questions. And then the next question they need to ask is, which program contractor is that facility, care home, or nursing home contracted with? So for example, if you have a care home that only contracts with Mercy Care Plan, even though in Maricopa County, the Alltex member has a choice, right? They can choose between Banner University, United Healthcare, or Mercy Care Plan. If the home they're living in only has a contract with Mercy Care, can they live anywhere else? Can they be on any other program contractor? No, they need to pick Mercy Care Plan. Okay, so it's just really important for them to understand that. And then the last question that I really want to touch on here is how long does that provider or that facility require that person to private pay before they allow them to roll onto the LTEX program? As many of you might be aware of, and many of you probably not, LTEX contracted homes don't get very much, right? They can't get the private pay rate, otherwise we would bankrupt our Medicaid system. So Medicaid has a specific amount that gets paid out for each member, and the program contractor in turn has to provide not only the long-term care, but the acute care side of things. So that means if that person has a hospitalization, they also have to help cover 20% of any unpaid medical bills that Medicare doesn't cover if the person doesn't have other health insurance. Well, the program contractor only has X number of dollars, so they can't pay all of those dollars to the care homes, to the care providers, to the facilities, to the non-medical home care company. They can't do that, so they have to limit the amount that they pay. So lots of these homes, care providers do require X number of months for that person to private pay. You need to know that before you place your loved one in that care home. We had a person the other day that happened to. The care home, they were getting ready to do the move, they did all the paperwork, and then we met with them and they said, hey, go ask this question. And the care home said, oh yeah, we require 2 years private pay. Well, our customer did not have 2 years of money left. There was no way they were going to be able to meet that obligation. So that care home had to then be taken off the list unless they were willing to negotiate that down to a different number of months. Okay, so only information. I know that not very many of you do what I do. There's a few of us out there who do what I do, but it's important because 1 out of 2 people in your world, either you, your spouse, a family member, is going to need long-term care. And if you haven't done a good job of putting money aside for these kinds of expenses, you're going to be relying on these types of programs to help you pay for that. You need to have some background knowledge to be able to do that for yourself, and also have any clients out there that might be getting up there in age. Okay, so keep that in mind. All right, so the benefits of the LTEX program, I've touched on them a little bit already, but I still like to give you something to look at there. The medical services are also known as acute care. That's why I keep referring to them as acute care. This particular page gives you a preliminary list. Does it include every single thing under the sun? No, but this gives you a really good idea of what they are referring to when they talk about acute care or medical services. For long-term care, it's going to be things like this: nursing facility, hospice, attendant care, assisted living, so on and so forth, okay? So those are considered long-term care expenses, and that could be up to and including home-delivered meals for an elderly person or a disabled person. LTEX is also going to cover their Medicare Part A premiums if they are QIMBY eligible. I'm going to talk about QIMBY in a little bit, so bear with me on that. It also covers the Medicare Part B premiums. So if there's a resident living at home in their own home, it's going to free up about another $145 a month out of their Social Security check that they can use to help pay for their bills. Access, or LTEX, is also going to help cover the Medicare deductibles and the coinsurance if they have no other coverage out there that they're utilizing. And they're going to do the Medicare Part D premium up to $32.09 per year. And again, we're going to talk about Medicare in a little bit too, so I will touch on that, what that means. And then everybody who qualifies for both acute care access and the LTEX access benefits are going to qualify for what's known as low-income subsidy, which is a subsidy to help pay the prescription drug premiums and lowers the out-of-pocket costs for the member. Okay, so many times they end up not paying very much at all. All right, I'm going to talk about the veterans benefits as well. Again, I don't want to spend an inordinate amount of time on these things because there's just so much. I could literally spend, I've spent 4 hours on LTEX at a presentation one time. I've spent 2 hours talking about veterans benefits one time. I could be here all day, you guys. And so I can't obviously go into all of that, but I want to make you aware of these things because, again, we deal with a lot of aging population and we want you to be have enough basic knowledge to help people to know that these things exist. Even if it's not something that you want to tackle, there are lots of other CLDPs that do have these additional services as part of their service package. So you can refer them to other CLDPs who can help them. But if you don't know about that, if you don't educate your clients, they could be flying blind or just randomly spending their money for an extended period of time without understanding that there are things that they can do to help them qualify sooner rather than later. So the Veterans Benefits Checklist that I just want you to kind of refer to is the person a veteran or a widow of a veteran? They have to have served during wartime. Most of the people that we're kind of seeing the tail end of the World War II veterans, those ones are starting to get up in age, and we're not having as many of those as we once did. We're seeing a lot of Korean veterans and a lot of Vietnam veterans now. So those are the primary ones that we tend to see and consult with. You have to have 90 days of active duty if you served during those prior periods. The numbers are different for the current wars, the most recent wars. You have to have been honorably discharged, or the veteran has to have been honorably discharged. You have to have low assets or resources, low income, or you can have high income and high medical expenses, and you need to have need the assistance of somebody needing help with their activities of daily living. Again, bathing, dressing, grooming, toileting, mobility, transferring, eating, those things. Now, there are several different benefits that are out there. They do have eligibility requirements. So again, not going to go into all the minutia here. I put this on your screen just to kind of help you guys understand. I do believe it's in your packet as well, just to kind of help you understand the process that VA is going through to calculate income eligibility. Now, on the previous screen, I mentioned that a person has to need help with activities of daily living. That's only if they're going to be applying and asking for the aid in attendance or housebound benefit. So if you are a veteran or a widow of a veteran whose income is below the threshold, you don't necessarily need the assistance of other people. If your income is low enough and you qualify for the benefit, you just qualify for the benefit. You still have to go through the process, but you don't have to prove your medical need for that part, only if you need the aid and attendance benefit. And so this is just kind of a little sheet that I came up with to kind of help people understand how the income is calculated. And then VA, or Veterans Benefits, they also look at assets. There's been a lot of changes to the VA program in the last year. And so it's very important that you do meet with somebody who's educated and understands this. I will tell you, there are a couple of CLDPs that I know that do this specific kind of work. They are accredited agents and they can help people navigate through the program. We consult with families because prior to all the accreditation requirements, VA used to let me help people with this, but they've gotten a lot more stringent on that. So I know about it. VA trained me. I got personally trained by some VA representatives, but now we have to refer that business out to accredited agents. So there is resource criteria. There's a lot more that is relating to the resources. This again is just that quick little synopsis. If you kind of plug in your data here, excluding the things that are traditionally excluded, is your net worth at zero and or below, and would you potentially qualify for those additional benefits? So again, just pointing that out to you so you can seek that information. And then VA now has a look back period. So if any assets are titled to a trust, if you have created any type of an annuity, if you've done any kind of special needs planning, or not special needs, trust planning, like irrevocable trust or transferring monies to your kids or things of that nature, VA is now going to be looking at that to determine if that affects your eligibility. And again, if you have any questions about that, I'm going to really encourage you to seek that information from somebody who is well versed in all the updated changes. Okay? Again, just trying to give you that basic information. And then this is not an all-inclusive list, but it is a list of kind of the people that come and consult with me. What are the current income limits? The maximum annual pension rate, that's what MAPR stands for. Those are the annual numbers of income that a person, that's the maximum rate that they can have. If they have less than that, and they would need to make up the difference. So if you have, as a veteran, only less than $13,000 of annual income, you can potentially qualify for a VA pension that would bring you up to that $13,752. Again, not going to go into all those numbers because it would take another half an hour to do that, but lots of good information, okay? All right, so let's just touch base on Medicare real quick, like here. Medicare has, original Medicare is going to be Parts A and Part B. You are eligible for Medicare when you turn 65. That's not going to be the same as when you qualify for your full Social Security benefit. The age is increasing on that. I think most individuals now have to be either 66 and like 3 months, 4 months, 5 months, depending on their age and higher to qualify for their Social Security, full Social Security benefit. But regardless, whether you decide to take your Social Security early or if you're still working, at age 65, you are going to be entitled to Medicare Parts A and B if you paid into the system the right amounts throughout your career. So A is going to cover your hospital stays and B is going to cover your doctor and outpatient visits. So kind of what we talked about earlier, the acute care side of things, that's what original Medicare is going to help you cover. The second thing that you have to evaluate when you become entitled to Medicare is whether or not you want to go down option 1 path or option 2 path. And I really like to think of it as 3 options. The first option is, do you want to just stay on A and B and not have anything else in addition to that? Because you can just be on original Medicare. You don't have to pick anything else to go along with that. But just remember, Medicare is only going to cover about 80% of the medical expenses and bills that you incur, which leaves you on the hook for the other 20%. As long as you have a tremendous amount of wealth and you have, if you have any major issues that happen in your life, 20% may not affect you that much. But for the majority of the population, that 20% can kick us in the hiney and kick us maybe into bankruptcy. So we want to give you the 2 options that you can have to fill or to help cover that extra 20%. Option 1 is you keep your original Medicare and you add a Medicare supplement insurance policy. Most Medicare supplement insurance policies pay the other 20%. So you end up having almost 100% coverage, generally speaking, 100% coverage for any Medicare covered service. Now, I always say that, right? Caveat, any Medicare approved service. It's not going to cover things like dental and vision and hearing, except for the limited pieces that are in the Medicare law that is covered by regular Medicare A and B. So a Medicare supplement will cover the 20%. You do have a choice of multiple different types of Medicare supplement policies. And I will tell you, in the whole United States, those policies, whichever plan you end up on, Plan G, Plan F, Plan N, Plan K, Plan A, whatever you end up on, is going to be the same across the entire United States. There's one company can't cover something different than another company. Medicare has done a really great job of protecting Medicare beneficiaries. So this is a nice standard policy. Many people will buy this policy because it's standard across the United States. They're going to pick the one that has the cheapest premium. And I don't blame you, right? But I do want you to take into consideration that the cheapest isn't always the best. So do your research and make sure that if you're evaluating Medicare insurance policies, that you're looking at the company's track record. Do they pay their claims? How often do they have premium increases? Are you going to have any issues with that? Is there a likelihood that company's going to go bankrupt? Is there anything else out there that you need to look at? So, we have, our particular policies that we like because we have researched the companies and we feel comfortable offering those type. Sometimes the premiums are a little more expensive, I'll be quite honest. But if you know that you have a real solid company that's not going anywhere and that's not going to bump up your premium substantially, then it might make sense for you to pay a little bit more on the front end just so that you have over your lifetime of having that policy, not extreme premium increases. Once you're on a Medicare supplement, it's annually renewable, which means that every year, as long as you pay your premiums, you will continue to get that benefit. It doesn't matter what new diagnoses come along. So if you get diagnosed with cancer 3 days after your policy takes effect, Doesn't matter. They're not going to drop you. They're not going to do anything to you like that, because you, as long as you're paying your premium, they're going to continue to cover your benefits. Okay. Now, if you choose a Medicare supplement, then you're also going to want to consider choosing a Medicare Part D, which is your prescription drug coverage. And again, both of these sides of option one are private companies. They are private companies that are vowing, or what do you call it? Trying to get your business, right? So they're going to keep on working and changing and modifying and updating to try to become the best so that they can keep you as a customer. With your Medicare supplement, you don't make changes to that. As long as you're happy with that coverage, you're generally going to keep that same policy. Within the first 6 months of turning 65, you are guaranteed issue. That means that it doesn't matter what your medical conditions are. If you turn 65 within the first 6 months of turning 65, you can enroll in a Medicare supplement without any underwriting. If, however, down the road you pick one plan and you decide later, nope, I want to pick a different plan, or I want to go to a different company, you will be subjected to underwriting. And that underwriting is tough. If you've had any medical conditions in the last usually 3 to 5 years, they're typically either going to rate you higher, which means you'll pay a higher premium, or they can decline your coverage altogether. Okay. With your prescription Part D plan, you get a choice of plans every single year. The annual enrollment is from October 15th to December 7th, and you can pick a new plan every single year if you want to. All right, let me take a little drink of water here because my throat's getting a little dry. I told you guys I had a lot of words that I was going to say. All right. Your second option with Medicare, in terms of trying to make sure that you cover that 20% that's not covered by Medicare, is to enroll in a Medicare Advantage Part C plan. Now, a Medicare Advantage Part C is, all of those are offered through private companies. That's not a government plan in the sense that you're getting it through the US government. You're getting it through a private insurance company who's gone through a lot of work and effort to provide a plan and to meet the Medicare guidelines to be able to offer that plan. What you are doing with a Medicare Advantage Part C is you're taking your A and B and you're giving it to the Medicare Part C company. So you're no longer considered covered under original Medicare. You are taking those benefits and you're giving them to this company, and this company in turn agrees to provide those same Medicare benefits within their plan, and they can provide additional benefits. Many of the plans also cover the prescription drug coverage, so you aren't going to have a separate Medicare prescription drug plan if you're on a Medicare Part C. If you pick a Medicare Part C plan that doesn't have prescription drug coverage, if you decide to enroll in prescription drug coverage, you cancel the Medicare Part C. So it's really important that you understand the two different plans, because you don't want to hurt yourself or mess up your eligibility for those benefits. Now, with a Medicare Advantage Part C, many plans, not all, but many plans, especially here in the state of Arizona, have low or no premiums or zero premiums. So there are zero premium plans, which is sweet. I have a lot of customers who are like, yes, I finally don't have to pay any premiums for my health insurance. But the caveat is that even though you're not paying a premium every single month for that care, you are having pieces that you are having to pay throughout the year. You have deductibles, you have co-insurance, and you might have some co-pays. Okay, so that's what you're giving up if you go with the Medicare Part C instead of a Medicare supplement. You don't have to pay a premium like you do over here, but you are going to typically have co-insurance, co-pays, deductibles, and things like that that have to be paid as you utilize the services. Now, there are some ancillary products that can be put into place depending on your eligibility that will help you cover some of those deductibles. And again, you would work with the Medicare insurance agent like me or my husband to help you navigate particular things. Okay. So again, lots of information. Medicare is its own ball of wax, and it takes a lot of education. Every year we go through at least about 40 hours worth of additional and recertification processes, because we have to make sure we understand what the current rules are. We have to also understand and be certified and appointed with each insurance company. And then each insurance company has its own set of products that we have to learn and understand. So it's not for the faint of heart. It requires a lot of time and effort. And so I just encourage you, even if you don't come to me, that's okay. I'm okay with that. There's lots of Medicare agents out there, but do seek help from somebody who's knowledgeable. What's nice about using an agent is that they're there for you. If you run into a snag or you can't find an answer, guess what? You pick up the phone, you give us a call, and we typically can get that answer to you same day. Okay? If not, sometimes within 5 minutes. So it's a really nice option for you. With Medicare Advantage and prescription drug plans, again, not locked in forever. You get open enrollment annual enrollment every October 15th through December 7th. There are other enrollment windows that exist throughout the year, so don't feel like once you make a decision that you're stuck with that plan, even that, especially with Medicare Advantage, you may have some other opportunities to make some switches. And then, as I mentioned earlier, Medicare supplements, the best time to enroll is when you turn 65, because later, if you have medical conditions, you may not qualify. All right, so let's quickly talk about the Access Medicare Savings Plans. The main thing that I want to talk about here is that if a person has low income, the numbers that are on the screen there, you may qualify for help paying for your Medicare Part B premium. For single individuals, that premium right now is roughly $144.60. If you're a married couple, again, you're getting that time. So if you can qualify your clients for this program, if they know that it exists, sometimes you can free up almost $300 in their monthly budget to help them pay their bills. If they qualify for QMB, that is like having a Medicare supplement for the low-income individuals, because QMB covers the Medicare deductibles and the co-insurance amount, so that 20% that Medicare doesn't cover. And you don't have to go to Access providers, because you can just be on QMB and have that benefit. If, however, you want full medical coverage, then you can qualify for Access if you qualify for QMB. And then you would enroll in an Access health plan, and then you would get your Access services through Access providers. Okay? And then for SlimB and QI1, it just pays the Medicare Part B premium. It doesn't add those extra benefits like QMB. But again, for lots of my customers, that extra $145 a month in their pocket, hey, sometimes that means they can eat or get a prescription filled or something along those lines. For these particular programs, there are no resource or asset guidelines. And so they literally could have $1 million in the bank and it's not going to affect their eligibility. Now, caveat to that is if that $1 million is in a bank account that's earning interest, that interest is considered income against the eligibility income limit. So what I would say is if they have very, very low income, even if they have really high assets, the benefits of Access may outweigh any interest or dividends they may be receiving, and they may want to evaluate that to determine, whether it makes sense to put that in a non-interest bearing account to qualify for these benefits. For people who are low income, medical benefits can, again, make or break you. So that may be worth checking into. Medicare Extra Help Subsidy is for people that have lower income, higher than the QMB, SlimB, and QI1 limits, but still fairly low income. They have to have no more than the screen, and this is going to help them subsidize their Medicare prescription drug plan premium, and it'll reduce their prescription copays. Again, that's going to be sliding schedule. In your packet is the NCOA sheet that I put in there. It talks about the low income subsidy programs right on that page and gives you all the information that you need. Okay. So let's talk about legal documents, because obviously that's why we're all here, right? We all prepare legal documents. Not everything that everybody prepares is the same. Some of us are in bankruptcy, some of us are in, divorce, family law, lots of different areas. My particular areas that I focus in are more estate planning and life care planning. So that's really going to be where my bent is going to be, where my expertise, knowledge is going to be from. So I just want to say, and in the state of Arizona, only 1 in 4 people has any type of life care planning documents in place. Now, I would hope that that statistic was way better amongst us certified legal document preparers, because by all means, that's what we do for a living. However, I will tell you that that is not always the case. So I want to encourage you, if you are over the age of 18 or just turning 18, or you're 18 or above, please, please, please get your life care planning done. What do I mean by life care planning? I'm talking about your financial power of attorney, medical power of attorney, living will, and mental health care power of attorney. So 4 of those documents on that page there are really going to be critically important for really anybody who's over the age of 18. And that is because we are not guaranteed to be competent tomorrow. Just because we're having a good day today doesn't mean we're not going to get in an accident on the way home, or we're going to have a stroke or something of that nature. And so I am going to be the first person who's going to be on my soapbox, and I'm going to tell you, you get your documents done. Because if you don't do that, somebody else is going to have to make those decisions for you, but without the proper authority, they will have to go to court and become your guardian and conservator. And then the court is going to be involved in everything really that they have to decide from that point forward. Things like selling houses to pay for your care, or cashing in assets, or anything of that nature. So these simple documents can help you put into place a plan so that somebody can make those decisions for you. Again, I'm not going to try to beat a dead horse here, but I just want to make sure you guys know those documents are available for free. Even if you don't practice in that area as a CLDP, just go out and get the documents for free on the websites. The Superior Court of Maricopa County does have a power of attorney, financial power of attorney form. Even this very basic document, it's not very detailed. It doesn't have a lot. It's a very short document. Even that very simple document, when I've had customers who have done that, it typically gives them enough authority to pretty much handle anything that they can handle. I've actually been able to utilize that to help my families create income-only trusts or special needs trusts for individuals that couldn't make those decisions for themselves, because it says doesn't limit your authority. So even that is better than nothing. And then the Arizona Attorney General's website has the life care planning packet right on it. You can just download that, fill it in. Those documents only need to be witnessed or notarized. You don't have to have a witness and a notary like the financial power of attorney. So one of the things that I have made a very conscious decision to do in my business, and again, you decide what you want to do in yours, but the decision that I made was I would rather my clients know that these free documents exist, even if it means that I'm not going to make any money preparing those documents for them, because I would rather them have something in place than nothing in place, because I don't want to encourage people to have to go to court to have to deal with these kinds of issues. Okay. All right, so there is a question. It says, the healthcare power of attorney on the website, is it valid for other states? So I'm going to use a general statement here. Again, you'll have to seek legal counsel for whatever state that you're going to, but the Attorney General form, the form that's on the Attorney General website, is going to be valid in other states if the other states have reciprocal laws and they accept documents from other states. So it's very important, if you do have a customer that's going from one state to the other, to maybe do some research and look those rules up. So for example, I had a client that had me prepare a financial power of attorney for Arizona. She didn't tell me, she didn't disclose to me she had a Louisiana property. So the power of attorney was created for Arizona, which only requires one witness and a notary. But Louisiana's rules required 2 witnesses and a notary. So when she tried to sell the Louisiana property, she couldn't use her Arizona power of attorney because it didn't meet the requirements for Louisiana. So now I just dig a little bit deeper every time I'm prepping documents for people to say, hey, is there any chance this is going to be used anywhere else? And then the particular software that I use the ForTrust software. I don't know if lots of you do that as well, but that software, you can change the state. And so So you can just look up the rules there. You don't have to go digging through their statute. You can actually use the software to help you figure that out, to see if additional witnesses or additional things might be required in that other state. It's worth asking the question, because if they don't have to do extra work, that's okay. I did have another client that just decided, let's do an Arizona power of attorney and let's do a New York power of attorney. So she just paid me to do both. And then we got them signed and notarized, and she was able to use the New York power of attorney for New York and the Arizona for Arizona. All right. So one of the other questions is, can I prepare a trust for someone in another state who has a special needs child? So here's always the challenge that you run into, okay? We are not certified to prepare documents in other states, right? Our software has the capability many times to prepare documents for other states. So if a person is in Arizona and they say, I want to do this document preparation and I want you to use the Louisiana, in the drop-down menu, I want you to pick the Louisiana state because I'm doing this for Louisiana, could you prepare that and get it signed? Of course you could. Now, does that mean that it's going to fly and do all the things it needs to do? Not necessarily, because again, are we licensed or contracted to prepare legal documents in that state? Not necessarily, right? I mean, not necessarily, we aren't. We don't know what their specific requirements are. So that may be one where you need to use a little bit of judgment and discretion. Again, if you're using software where the software has gone through the company has gone through the effort of making sure the rules are applicable for whatever state it's in, you can prep it in Arizona, but they would need to do the signing and whatever if they're doing it with you here in Arizona. Get wherever they want it and have it signed and witnessed somewhere else. But again, I would just use some judgment there and precaution, always some precaution. The software that I'm using, and I know a lot of people in our group use, is For Trust Software, and that's FORE, For Trust Software. Okay. And then in terms of what I charge to prepare a Miller Trust, I'm happy to share that with you. We have 3 different packages. We have a basic package, which is just the preparation of the document and a basic to-do list. It's $250. We have very detailed instructions for that if they decide that they want more than basic instructions for all text, to make sure that they're filling out forms right and they're doing some extra work that's going to make sure that trust gets through right and they're taking all the extra steps that need to be done. We have a $500 package. That's also a do-it-yourself package. We prep the document and they get it signed. And then we do a $999 package that's hands-on, where we're sitting down with people, we're getting the trust prepped, signed, dated, and then because of my background in understanding all text and the rules surrounding the income-only trust, I can sit down and educate them about what they need to know about the trust, how to fill out the all text forms, what additional steps that they need to take to make sure that that trust has the best chance of getting through their legal department and their policy department as approved. Okay. The next statement or next question is, isn't doing research against the CLDP rules? Well, yes, I would say to the extent, yes and no. So I think it's important if you are preparing a document for somebody and they're planning on using it in another state, you doing your due diligence to see that it needs a second witness, I don't think would be in violation of the rules. I may be wrong there, but I can't imagine that it would be in violation. Really, that's what you're looking for, is to see what constitutes a valid document in that state. So there's nothing wrong with you doing that kind of research. The research, and again, if you're using software, you don't have to do the research because the company has already done the work for you. You're using a pre-approved system. Somebody has gone through the effort of creating software that's doing all that work for you. I'm not pulling statute out. I'm not pulling all kinds of information out when I'm prepping documents when I use For. It's giving me prompting questions. I ask the client the question, they give me the answer, I answer it, and then it populates the verbiage. I don't do that.
I was just going to say, without a doubt, you can always update your individual forms, do the research that it takes to have accurate legal forms. which we're required to have.
Right. And again, that goes back to your responsibility of being a knowledgeable certified legal document preparer. You can only practice in the areas in which you're knowledgeable. If you haven't taken classes or done research or read books or anything like that that can help you to be the best document preparer you can, well, then you're going to make mistakes, and that's going to open you up to litigation. Okay. So just be very, very careful on that. Okay, so let's talk about in terms of estate planning. Although the first gentleman that spoke, the attorney that spoke, he kind of talked about all of these things. So I'm not going to rehash what he talked about here, just to remind you that these are the things that I use and that many legal document preparers use to help people with their estate planning. One of the things that I have done in my business is to really kind of help people by sitting down with them and consulting with them, not necessarily about legal document preparation, but really about the processes. So often I think that as a certified document preparer, we get a little caught up in trying to kind of be all, do all, but we don't always charge for that, and we don't always value the knowledge and expertise that we have. So I encourage you to think about, if you are really great at what you do, you have 20 years of experience or 15 years of experience or 10 years of experience, and you know how to do things, you can consult with people to help them navigate through some of that. So for example, I do a lot of end-of-life consulting where people are just completely overwhelmed. They don't even know where to start. So they'll sit down with me and they'll pay me a consulting fee to sit down and talk about, okay, do you have a will? Are you going to possibly need to do small estate affidavit? Do you need to possibly do informal probate? Do you need to do probate? Do you need to hire an attorney? Just asking all the appropriate questions to help them get to a solution. That's not giving them legal advice. It's educating them and providing them with enough information so they can make educated and informed decisions about what their next steps might be. You're not dictating to them. You're not saying, oh, you're going to do X, Y, Z. You're going to say, in your situation, based on how you answered the questions, it looks like these are your options. So that's just helpful information. It could be as simple as helping people understand that they're a joint owner on a bank account. You know, they may not understand that is not subject to probate. So just helping them by educating them about those little types of things and really valuing you. Right? You've gone through a lot of work and effort to be a certified legal document preparer. You need that to prepare legal documents, but there's nothing that says that you can't consult to talk to people about all of your knowledge and expertise, right? You might have read 15 books on estate planning and you've looked at every possible scenario. So just try to keep that in mind as a business. That I'm going to talk a little bit about that when I get into the next section. There are two books that I wanted to make sure that I pointed out to you guys. One is the Trustee's Legal Companion by Nolo. I don't know if you guys can see that, but the name is on the screen and the company is there as well. Yeah, if you want to take that up there, that's fine. Here's the other one too. And then the other one is the Executor's Guide. So honestly, it's kind of like me being, when I'm a Medicare insurance agent, right? Not everybody understands how to navigate the Medicare system, right? But as a Medicare insurance agent, I have access to lots of information as an agent. So sometimes people will call me and thank you, and they will ask a question because they've done some research and they can't find the answer. And because I know that, oh, I have the explanation of benefits in my system already saved, I just open it up, find the answer for them and provide it to them. It's the same thing with these books, right? If I read this whole book and I understand and I flag some things, when people have questions, I don't necessarily just answer things off the fly, right? I might say, oh, let me read, let me see what knowledge that somebody else has put together, and I can then read verbatim right out of the book what the answer might be in their particular scenario. Again, I wouldn't consider that research, right? That's somebody else has put together a book, I read it, and maybe the average person doesn't know that this book exists. So then I'll say, well, in the Nolo book, for the trustee's legal companion, they say that a trustee is supposed to do X, Y, and Z. These are the things that are listed in the book. Am I speaking from my own personal experience? No, because I'm using somebody else's knowledge and information, but I'm helping somebody to understand the rules and educating them about that so that they don't make mistakes in their planning, okay? Or in their facilitation of that planning. So these are some of the legal document issues that I see with regard to Altex. And again, I bring it up because, again, we have aging population. Whether or not you have a person who's going to be going on Altex, I don't know the answer to that, but I want to plant the seed, right? I'm all about planting seeds of information. So if you're meeting with a client who's talking about long-term care, they're talking about going on to the Altex program, and they say something, you can be like, "Ooh, Carol mentioned something about that. Maybe I should bring that person, maybe I should bring Carol into that conversation, or maybe I should have them consult with Carol to make sure that they understand what that is." That doesn't mean I want to take your business away from you. It just means that there are some things that, as a document preparer who doesn't do all text, you're not going to necessarily know. You're not going to know because how would you, right? That's not your expertise. So the first thing that I always want to point out is that the estate planning may have to be completely redone. Why do I say that? Especially for a married couple, there's a well spouse and there's a sick spouse. Typically the sick spouse is the one that's on Altex. Well, all the estate planning that they did was for them as a couple. Once that person goes on to the Altex program, Altex requires that all of the assets be transferred to the well spouse. Well, what if it's a second marriage or a third marriage? What if there's a prenup? There's just a million things that could be in place there, right? That we have opportunities to say, hey, we need to think about the planning, because what Altex is telling them may be legally valid for Altex. It's not necessarily legally valid for that person or for what their plan was or for what their purpose was. Additionally, any assets that are held in the name of the trust, the whole point of a trust is to prevent probate, right? But if Altex requires you to take everything out of the trust, then you now have a new issue, because you have to redo the planning in such a way to protect that estate from having to go through probate when the person dies. So these are things that you have to start thinking about. If a well spouse dies first, there needs to be planning in place to protect the Altex members' eligibility. We do that a lot of times through a trust, because the well spouse, rather than holding everything just in their name, subject to regular probate rules and things like that, by them creating a brand new trust, they can name their spouse. They don't have to disinherit them, right? They name their spouse as a special needs beneficiary inside of that trust. So the trust is for their benefit during their life, and then when they die, it goes to their special needs spouse, right? But if you don't have that plan in place, you don't have that special needs provision inside of the trust or inside the spouse's planning, then the other spouse now is going to inherit all of those assets and potentially get kicked off the program. The reason I bring this up is because it happens all the time. Those are a lot of conversations that I have, is people who had a well spouse who got sick and died before the person in the nursing home or in assisted living. And now they inherited a house, they inherited cash, they inherited a life insurance, they inherited all this stuff that's going to kick them off the program, because the resource limit is only $2,000 for a single person. So by being proactive, we can help those people navigate through that and get some planning in place to protect that special needs beneficiary. A special needs trust that's managed by somebody other than the Altex member is going to protect those assets from spend down. They're not going to have to spend them down, even though they're already on the program, because the special needs provisions say it's at the trustee's discretion, okay? If the trustee doesn't want to spend money on medical care for that person, they don't have to. They can just keep those monies out there in that trust until that person dies. What I like about that, by creating that special needs trust, is that you are always looking at the best interest of the original couple that you met with, right? As long as their original plan is in place, they're still taking care of each other, And then when one of them dies, the other one's still being taken care of. Okay, so think of that in terms of how can I best help them long term. And then I brought this up earlier. Houses and trusts do not work for initial eligibility, but again, don't just take it out unless the first continuous period of institutionalization is established. That's a lot of lingo, right? Not the average person's going to even understand what that sentence means. So that's why it's important that you consult with somebody who understands All-Tex eligibility, and sometimes by planning appropriately, sometimes taking the house out of the trust is the only spend down that they need to do. I've had customers come to me before their spouse had a first continuous period of institutionalization, and we've put houses in trusts because we wanted to bump up the amount that the well spouse got to keep, and then taking the house out is what qualified them for the program. Gave you a little trade secret there, okay? All right. Income only trust, this is a huge misnomer. Lots and lots of people think that the income only trust is created to protect the assets. Nothing is farther from the truth. It is not for assets at all. Its purpose is to gain income eligibility for all tax, period. Okay? Disabled under 65 special treatment trusts. This is a way to protect assets from spend down for disabled individuals under the age of 65 when the trust was created. So you can create this prior to age 65, and even if they're over 65, the assets will still be excluded. However, All-Tex is the remainder beneficiary at the disabled person's death. So sometimes when we do our education and our talking and our planning, sometimes we use this and sometimes we don't, especially if the person doesn't think that they want the state to inherit the money that's left. Sometimes they just want to spend it themselves. So just again, helping people understand how that works. And then again, reiterating the special needs planning. It should always be a part of all estate planning because we don't know what condition the heirs will be in when they inherit the funds. Special needs trusts protect an heir from having to spend down their assets as long as they are not their own trustee. So you can't name them as their own trustee of their special needs trust because then they have control, right? And I say this because, for example, in the For Trust software, you have a choice to use the long distribution, special distributions paragraph, or the short version. And I encourage people to use the long paragraph and to make sure that they have Medicaid planning in their trust authorities as well as their power of attorney authorities, because this is going to give you the ability to do some of that special needs planning in case somebody that inherits your stuff has a special need at that time. We don't know. The special needs or special distribution paragraphs are specifically in your your trust or in your testamentary wills, where you can have those paragraphs in there in the event of, right? Just in case something happens. So be thinking about that. Not everybody who does estate planning really thinks about the possibility of an heir being disabled if they're not disabled at the time that they come in. So think about that. Talk about that with people. Again, don't tell them they should or shouldn't. Just present that as an option. Hey, there's a special distributions paragraph. Here's some reasons why you might want it. Here's some reasons why you might not want it. Again, you're educating and they're telling you whether or not to include that. You're not dictating to them whether they should or shouldn't. Okay, but provide them information. They don't know better, right? They don't know all the information, but you probably do. All right, so I'll talk more about my services at the end of my second presentation. That's the end of this particular one. Is there any questions about this particular stuff that you guys want to ask at this time before we break? And then we'll come back and I'll do the growing and protecting your CLDP business. Again, I told you guys, I had a lot to talk about.
And I realize we're going a little over the anticipated time period. But that's just because we had a little bit of difficulty at the beginning. So we're going to go, the second presentation is much shorter. And so, I anticipate we're going to go to 1:15, 1:20.
I would say, let's say 1:20, 1:30,
Yeah.
just to be on the safe side, but yeah, I'll try to wrap it up.
Okay. And then, so we're going to take a brief break just to get to get set up for the last part of the presentation. When we come back in, we'll get right into that. And then just bear in mind, at the end of the presentation, I'm going to be showing that last word for verification purposes, and then we will be done at that point. All right. So brief, just a couple minute break so we can get set up for the rest of it.
We just need to unmute. Hi guys, everybody back? All right, so I'm showing that in order to meet our 5-hour requirement, I have about 32 minutes left, so I'm gonna do my best to stay within that time frame. Kind of bear with me though. This particular section is new to me. I've not done this presentation before, so I may get off on a tangent, which could happen. I'll do my best to stay on track though. And I just thank you guys for being here today, and I thank you for giving me the opportunity to share with you. So my next presentation is going to be about growing and protecting your certified legal document preparer business. I may be talking to the wrong people today. To be quite honest, there are lots of people we are all self-employed, most of us. I would say generally most of us are self-employed individuals. So we probably already do all these things. But I have found in my years in business that there were things that I didn't know. There were things that I was doing or not doing, information that I just wasn't aware of until I read books, attended other classes, exposed myself to other kinds of companies and research and information. And I just thought, I always have like lots of great ideas, and I share them with my friends and my business associates, and they're like, hey, Carol, you should tell people about that. You should teach about that. So I thought, what the heck, I might as well try and help you guys to grow your business. And again, I might be speaking to the wrong audience. Maybe everything I'm going to tell you today, you're going to know. But I'm hoping I might tweak your little brains a little bit today, just so that you can learn something new and that you will take that information and grow and protect your certified legal document preparer business. So the first thing that I want to talk about is the idea of workflow and procedures for your task. So obviously we're not in a classroom setting. I can't really have you guys raise your hands per se, but I want you to think about how many of you right now outline your workflow and procedures for each task that you do, both as a certified legal document preparer, for any other businesses that you do, and also as a business owner. What are the things that you have in place? How many of you track your time? Do you guys use any type of a log or anything that helps you know how long does it take me to prepare an estate planning portfolio? How long does it take to prepare a beneficiary deed? So think about that. Also, do you know how much you make per hour for the work that you do? I will tell you, there was a point in my career where I didn't know. And so it was really hard for me to judge, should I increase my rates? Should I change my legal document fees? How should I calculate what I'm doing? And so think about that. And then what tools are you using to track these things? Are those things that you could create and develop into a presentation to help other business owners? Or perhaps you can be a speaker at an event and you can teach us some really great things. So the first thing that I want to make sure that you do is think about writing your procedures and creating task lists. And the reason that you do this is because you are one person, but you may want to add staff members or other people to come in and help you to grow your business. I find that it's very helpful to hire administrative assistants. What can they do that I can take off my plate that they could do for me that doesn't really require my brain? It just requires somebody else to do the task. But if I haven't taken the time to write the operational procedures down or to create a task sheet with step-by-step instructions, how can I be sure that they're going to do all the steps necessary to complete that task? And then how can I really hold them accountable if I've not given them a parameter in which to reach that goal? So this particular page in the PowerPoint shows you a table of contents for one of my chapters. So I created an operations manual for my business. Chapter 3 happens to be about office guidelines and equipment. And so you can see here, these are all the different pages that we created, post office procedures and copier rules and scanner and faxes and voicemail and how to be the lead person for phones, how to order supplies, all of these task sheet so that I can say to my staff, hey, we need some stuff. go figure out what we need and order it. I don't want to have to be the person who's managing all the minutia. And by creating these task lists, I can give somebody else those jobs so that I can spend more of my time on the things that bring in money to my business, which is meeting with clients and preparing legal documents. Here's an example of post office procedures. This is not the whole page. I didn't want to give you the whole page. I just wanted to give you a snippet so you could see kind of how detailed I got. And the reason that I do this is because I want somebody to be able to do this without me present. I want them to have enough guidance and information that they can take the task and do it on their own. So it includes what supplies are they going to need, what they need to do, how they need to do it. Again, this is not the whole sheet, but this just gives you an idea of what they need to look for. I don't want to have to sit and train my people what a peach card is or a yellow card is. They can learn how to do that by reading these procedures. And when I hire new staff members, this is what I have them do. I go, here's a task. I want you to do it. Go look up the procedures. If you have any questions, let's talk about it. And once they're doing the job, if they see, oh my gosh, this is outdated. Carol, when was the last time you created this? And you can see this one was 2007 was the last time I had to write this procedure on this particular task. They can fix it, right? If they're doing the job, they're the best person to go in and make any modifications or changes to it. So this is something that we do. Oh, did I go too fast? Let me see. And then the second thing that I use in my business is what I call my time log. So the time log, I have a generic one that just basically has the date, start time, end time, the number of minutes I had spent on it, and then purpose is just blank. This particular page happens to have a legal document time log. So for example, do you know every step that you need to do to complete that task? So I know that preparing a legal document from start to finish isn't the only part of that job that I have to do. There may be review time, there may be prep time, there may be scheduling appointments, preparing the binder, the folder. There's all these tasks that are associated with what I do. And by tracking every step of the process, then I can calculate how much time, how much costs are associated with the different work that I do. So do you know your costs? Do you know how long it takes you to start and to finish a task? Do you know every step? If you were training another certified document preparer, would you be able to tell them all the steps other than physically going through it? Again, the more that you can put in writing for your company, the easier it will be for you to train other people that come on board, okay? So this is just an example. I like to kind of just show people, you won't be able to see the details on here, but this is just kind of a completed sheet. In this particular one, between fees and everything, I wrote down all the fees that were associated with it, all the time that I spent on it, any additional time that other tasks that I don't have on here pre-written. So I just kind of do all of that just to kind of help me. And then I keep a spreadsheet for that. So that's the next thing. Do you track the information about your business? Do you know how much time you spend on a project? Do you know your hourly wage for that task? Do you know if your business is growing or declining? Do you know which document preparation portion is your most lucrative? Which one are your duds? Which one maybe you need to increase your price? Maybe you need to reduce your price. How do you know that if you're not tracking your information? So these are just some of the spreadsheets that I've created. I'm sure there are probably easier ways for people to do this, but I'm kind of a fuddy-duddy with regard to how I keep track of things. So I create my own spreadsheets. I have a lot of things autofill. I create, background data in there so that when certain things are filled out, other things automatically fill in and calculate. So for example, the orange one on the top, I keep track of every All-Tex application that I help people with, what the 45-day due date was, what was the actual approval date. Just because it's due in 45 days doesn't mean they get it done in 45 days, or maybe they got it done before the 45th day. So how much time am I spending on the application from start to finish? And then I average that for the whole year for all of the work that I do on my cases so that I can say my average processing time for an All-Tex application. So for 2019, it was 39 days. If the average processing time frame for Altex is 45, I'm doing pretty good if my average is 39. There was a year where it was over 120 because Altex was just that far behind in processing their stuff. It didn't matter how good I was. They were just slow. But I can see throughout the years they've gotten better and better because they've processed my cases faster and faster. The second little thing there is for my, let me see. Oh, that's for tracking how much I make per case. So again, by keeping my little time log, the one that I kind of showed you on the other page, I go into my spreadsheet and I type in I add up all the hours, all the minutes that I spent on the case. I put in all of the expenses that I had to pay out on that case. And then I have it automatically calculate how much time, what was my average time, and what was my average time on all the cases that relate to that. So I put all my estate planning group together, all my Altex cases together, all my income only trusts are together. And that helps me to know how much time on average am I spending for one particular task. In your handout, you'll see there that I gave some examples. So my Altex planning, for example, takes me between 25 and 50 hours, depending on the type of case. Some types of cases are not as complicated as others. So I might only spend 25 hours on them. And then I have some cases, especially now with the 5-year look back and literally looking at 5 years worth of records, they're going to be taking me between 40 and 50 hours. So that helps me to see, do I need to maybe increase my cost on my case to help me cover that extra time? I'll give you a perfect example on beneficiary deeds. A lot of people think, oh, beneficiary deeds are easy. But again, I do a very thorough job of asking enough questions to make sure people are giving me the right information, so we're not taking any risks or unnecessary risks of making mistakes on anything that we're doing. And I found that between the preparation time or the data collection time, the preparation time, getting the signings done, we include in our signings doing a home visit if necessary. Well, you know, the valley is very big. I could be in Sun City one day and Yuma the next, and sometimes. So I have to calculate how much time on average, without the outliers, of course, like Yuma, that I'm spending on any particular document. And I found with my deeds in particular, I was giving away my time. You know, I wasn't making any money on my deeds. Yes, I was making money, but by the time I calculated all the time I put into it, my hourly rate was less than minimum wage. And I went, well, that's just silly. I'm not charging enough for this document. So then it allowed me to create a better pricing structure for the work that I do on those kinds of things. So, and again, you might have some, loss leaders. You might do a beneficiary deed at a loss because it maybe brings people in the door to talk about estate planning. But you can't calculate that unless you've actually tracked that information. And so by doing the time log and then taking that data from the time log and putting it in a spreadsheet and calculating it out, then am I actually making a profit or am I just spinning my wheels over here? The next spreadsheet that I spend a lot of time on is my referral sheet. So I try to track who referred every person, what kind of industry are they in, if they have a company that's associated with them, what customer was associated with them. And honestly, I added a new tab on there because I was like, well, how much money am I making off of this particular referral source? So anybody that came in and actually consulted or hired me or did documents, whatever, I put the number that I made, what was my gross income off that client in the tally as well, because then I can look at it and say, oh, well, my best referrals are from XYZ company. Maybe I need to send them a treat because they're sending me a lot of business and it's actually turning into something. But if you're not tracking it, how do you know who to thank? How do you know who to spend money on? How do you know how to be proactive in your business? Okay. And then the last one is just my year over year. How much am I making every single month? And how much am I making over the whole year? And then I go year to year. I key in all the data for every month, for every year, and I track that. I've been in business for 20 years, and I can tell you every single year that I had a great year and every single year that I didn't have a great year. And I can tell you in which months I make the most money and which months I don't make the most money. So just keep those kinds of things in mind, because as a business owner, especially as a certified document preparer, you need to know, are you actually getting value for the things that you're doing? Because what you do is valuable. It's very important. Okay. And I just want to remind you of that. If nobody else reminds you today, I want to be that person that reminds you. The next thing that I like to do, and I had an attorney friend who told me that I should go teach this to all the attorneys. So no offense to the attorneys, but maybe she's onto something there. But this is also something that, again, I didn't learn right away. I learned it over time by not planning my time appropriately. And that is, how much time does it actually take, right? So if you're tracking your time and you know that your average processing time for an estate planning portfolio is 10 hours, you need to block that time on your calendar so that you have time to do that. I don't know about you, but I don't really like working 60 hours a week. I would rather not. But if I'm going to be working 60 hours a week, I want to make sure that that time is filled appropriately. I want to make sure that I'm not taking on more work than I can handle. So for example, I had a customer that retained me on March 6th, and she called me on March 25th, and she's like, Carol, I haven't heard from you. And I said, well, do you recall on March 6th that I told you the first availability I had to work on your case was March 26th? And she said, oh, yeah, you're right. I forgot that. So by putting all my appointments on the calendar, I could clearly identify, do I actually have time to take on any new cases this week? Or do I need to push them to next week? Or is that a task that I can delegate to a team member so that they can do that, and that can free up my time to do something else? So again, if you don't know what that is, track your time and create a calendar for that. There's a few things on here I need to update, but this is an example if they're doing estate planning portfolios and trusts, the kind of times that I've calculated out that it takes us to kind of get all of the pieces done. And I'm talking about from start to finish, from data entry to getting any thank you cards out to, getting the binders ready to actually prepping the documents and doing the signings and travel time. So all of that is put on my calendar. I actually create separate appointments for every single one of these things so that I know on average in a spousal case, for example, it's going to take me 12 hours or 11 hours or 10 hours or whatever the amount of time is. And I've done this for every single task that I do, whether it's alt-text planning, whether it's a deed, life care planning, estate planning, if I do Medicare, whatever it is, we block the time on the calendar to make time so that we can get our work done and we can legitimately tell our customers what the next time that I'm going to be able to work on your case. And this makes a huge difference. I just had a customer yesterday who said this to me. They said, Carol, the one thing I appreciated about you was that you said to me when we hired you, guys, I have a lot on my plate right now. The soonest that I can get to you is Thursday at 10 o'clock. So that's when I'm going to work on your cases, Thursday at 10 o'clock. And he said, I'll be damned if at Thursday afternoon, because I knew you were working on it in the morning, that by the afternoon you had sent me an email telling me you had completed the work. He said, that was amazing. I don't know that I've ever met anybody who said, I'll get to it on Thursday and actually finished it and completed it on the day that they said. It makes a difference. How you treat your customers really, really matters. Okay? So again, I can spend a lot of time talking about all these things, but we're running out of time. So 13 minutes left. I'm cruising now. All right. So the next thing about growing your business is your marketing plan. I want to remind you over and over and over again, it is super important that you have a plan. Plan your year, plan your campaigns. Who's your target market? Are you going to start a campaign? Are you going to end a campaign? How much is it going to cost you? What are the costs when it's all said and done? What was the outcome? Was it worth your time and energy? So for example, last year I did a Yelp thing where I spent a bunch of money on Yelp to try to see if it would make a difference. And I got to the end of I had signed up for ongoing until I canceled it. And after 2 months, I had nothing off of that. And I was like, well, it's $400 a month. It's not actually producing anything that I thought it was going to be producing. So I'd rather spend my money in another area. So just as an example of something that I've done. So in your packet is just kind of a snippet of this. Oh no, there's not a snippet of this, but there's the information that's on this sheet. So again, I create a sheet that I track all of my campaigns, and I put all that information on there. That's on the left side of your screen. Social media is a new thing. I think a lot of us are a little older, and so it's not as common for us to use this, but I do think this is going to be the future. We have to start thinking about how we can use social media for our businesses. And then also collateral. I brought just some, obviously you're not here, but I just wanted to kind of show you like some of the things that we use, our business cards. And then I have a brochure that I use for my Medicare. I send out flyers for people who are thinking about doing Medicare insurance as a business. Something that I created recently are these bigger flyers. These meet the 55-cent stamp requirement, and they're bigger, so they stand out when you mail them to people. So I've kind of done one for my Medicare, one for my other planning business, and it gives you something to hand out, something to mail out, something to get in the hands of people so that they can refer people to you. And then the other thing that I like to encourage you to think about is direct mail campaigns, gifts, as long as it's appropriate for whatever resource you're using. Hosting events is a really great way to get in front of a lot of people, because even though it's not your event, many times if you host, they'll give you a commercial where you can get up for 5 minutes and talk all about all the lovely things that you do. And you help pay for that maybe sometimes, and you contribute, but you get a little bit of something out of it as well. And then also donating your time. So donating your time to organizations and things like that. Oh, here's the sheet. So again, these are just samples of things that I've created. Obviously, they're not, perfect for every person, but it's something that we use. And then think about what companies naturally fit with yours. What organizations need your service, and who else can you reach out to make a connection, right? You don't want to be at the end of your day and you don't have any resources, any new referral sources that can help you grow your business, okay? I do have a question. It says, do you sell these types of templates? So I have not sold my templates. However, I do a lot of consulting with small businesses. So if you pay for my consulting time, we can create a template for you, okay? Hopefully that's helpful to you. All right. And then this is an area that, although I am promoting another company service, and yes, I have my own send out cards business as well. Although it is another service, I want to tell you guys that I started using send out cards. It's a subscription service where you can go in, key in all your contacts. They have all kinds of cards. They have campaigns. They have gifts. They have all kinds of really great stuff. And one of the things that I have learned from using this system is that I do it for all my businesses. I do it for Medicare, I do it for Alltex, and I do it for my legal docs business. My legal documents business has doubled because I use this service. So I want to tell you about it because I'm excited about what it has done for me. And if it can help you, by all means, let's help you too. So it is a way for you to keep in touch with your customers. There's an online sign-in, as well as you can do a phone app. In less than 60 seconds, you can choose a card, add a personal photo if you want, write messages, and then click send. And the company will print, stuff your envelope, stamp it, put the address on the envelope, and mail it for you. Man, I will tell you guys, it is like having an extra staff member because I don't have to do all that work. Think about it. How many people would you like to remain in contact with on a regular basis? We have a referral source campaign where I send out cards to people like every month and a half, and I do it over a whole year period of time. So if I meet you, you're going to get a card system from me, and every month and a half, my name is going to be in front of your face to remind you that you're important and I want your business. The same thing with my legal documents customers. I created a campaign to remind them, hey, thank you for getting your stuff done. Now you're not you're not a bad statistic, you're a good statistic, right? You've gotten your stuff done. Secondly, I reach out to them to remind them, hey, have you gotten your stuff done? Did you fund your trust? Did you do this? Did you do that? So I have like a little reminder card that goes out. And at their 1-year anniversary, especially with my estate planning portfolios, they get brownies. You see those brownies in the corner there? They are like drugs. They are so delicious. I'm telling you, I send these out on my estate planning portfolios. That's why my business has doubled, because people get this brownie and in there is a card celebrating their anniversary and reminding them that they need to pull their documents out and look at them to see if anything needs to be changed. 50% of my clients call me and say, Carol, these brownies are like drugs. They love them. And then they say, and I pulled out my documents and it looks like I need to fix X, Y, and Z. I need to do some new things. I need to add this. I did this. I changed that. Oh, I bought a property. I forgot to put it in my trust. Holy cow, guys. It's like, boom. I don't even have to think about it because I automatically send all of these things out and they just call. It's fantastic. I love it. Sorry, I'm going to just go on and on about it. But this is just some examples. So like this is a card campaign that I do for our Medicare. We have a 6-card campaign for them. I have some other cards. So we do postcards to keep some of the costs down. I also use it for my family. Obviously, I send them cards to tell them how much I love them. It can be as personal as you want. I told my husband I was going to share the inside so that he could see. But I just remind them how much I love them, and I use it for that. So it can be used for customers, referral sources, and friends and family. And I want to say, guys, you're one person. You can't do everything. But what can you do? You can put into place services that will help you to be that, okay? I do want to point out that if you decide that you like this, these are the options, but cool little thing, I have become an affiliate. Obviously, if you sign up on my site and become an affiliate, you'll be in my group or whatever. I don't really care about that as much. I want to just make sure that you guys know that this exists. But the affiliate opportunity right now, they have waived the fee. So it normally is $59 a year, but they've waived it up until Monday to $0. So you don't have to pay that if you decide you want to try it. Here's what I do. I share this with people, and the money that comes in, I use it to offset my marketing costs. So it's just a way for me to add more money to my bottom line. Okay. All right. And then diversification. This isn't in your packet, but I just wanted to remind you guys, what other services or ideas can you incorporate into your business? Are there tools or resources that you can sell, that you can add to your list of things that you can do? Is there anything you already invest in or use that you can talk about or add as part of your marketing campaigns? And then in your packet, I put a list of everything that I do because I don't have time to run all these businesses, but by being affiliates and things like that, when people ask me questions and I tell them about it and they sign up, then I just get extra little revenue here and there. And I'll tell you, $20, $50, $100 here or there. It doesn't seem like a lot, but in your marketing budget, if you could drop your marketing budget in half just because you shared something with somebody else, why wouldn't you do that? And any additional residual income is good for your bottom line, okay? I don't spend a lot of time doing all this stuff. Obviously, I don't speak every day about this because I don't have time. I'm busy running my CLDP business. But what can you do to diversify your business and just make more money? All right, so now we get to the part of the business. And that is protecting it. So I want to make sure that you guys know that there are things that you could consider putting in place. I'm not going to say should. I'm going to encourage you to view it from a should perspective because it's going to protect you. The first is errors and omissions. I will tell you, when I first became a CLDP, I reached out to errors and omissions companies and I got quotes between $5,000 and $10,000 a year. As a brand new business, there was no way that I could afford that. So I didn't have insurance. I will be quite frank with you. I didn't have it because I couldn't afford it. So it wasn't until later when I was like, holy cow, I'm starting to get a lot of legal documents customers. I need to cover my behind here because I'm a human being. I could make a mistake. And if they get mad at me and sue me, where the heck am I going to be? I'm going to be out of business. So this company, Fox Point Programs, is a company that actually covers independent paralegals So it's one of the few companies that they actually have a plan for that. So in your packets, kind of their little overview sheet, they told me that I could become an agent with them because I am property and casualty licensed. I haven't gone through that process yet, but if you guys decide that you want to look at errors and omissions, if you go to the referral link that I put in your packet and you put in my information, at least they can give me the referral fee for that until I can figure out what else I need to do. But anyway, it's again, not a requirement. I'm not saying you have to do it through that or through me or even say that I even said it. I just figure, again, if I can add $60 or $100 to my bottom line, why not? All right. Next thing is liability insurance. Many of you have offices, and so you are required already to probably have some sort of liability coverage. But many CLDPs work from home. All right. So if you're working from home, you're not thinking about that, right? But are you keeping records on your server or on your computer? Are you keeping paper files in your office? What if your house burned down? How are you going to remake all those pieces of information? So think about having liability packages. I have a BOP policy as a small business owner. I have the BOP, the business owner's policy, and it's a prepackaged policy which includes both property and liability for my business. I also include in there professional papers. And if there's identity theft or anything like that, I have some protections in place so that if something like that were to happen, if for some reason a client stopped by and something got picked up and it wasn't theirs or whatever, I have something in place to help protect me against those kinds of issues. So I just want to remind you of that. I use Mark Dorico. Again, there's no affiliation, there's no money or anything, no affiliate fees or anything like that, but he has been my agent for a long time, and he is a really great guy and very, very helpful with all of those kinds of things. Workers' compensation. So if you are employing people and even if you are just doing independent contractors or something like that, do consider the idea of, if you have an employee, please put insurance protections in place so that if something were to happen to those employees, that you have some coverage in place. It's required by the law for any employees. If you have employees, you have to have workers' comp, but just remember that you need to have this in place to protect you in case somebody gets hurt on the job. I do that through the Hartford. Again, no affiliation fees or anything like that. It's just the company that I use. And then I do want to talk about this next little bit. I know it's going to go a little bit over, and I appreciate your patience, but I think it's important that you guys need to know these last two pieces of information, and that is protecting personally identifying information and HIPAA related information. So I want to remind you that many of us as CLDPs, not me in particular because I have other licensing and things like that, but there are CLDPs that the only business you do is certified legal document preparation. And many people do not feel that the rules necessarily apply to them, which may be the case. If you were to read the rule, the generic information about the rule, it may not necessarily apply to you. HIPAA, for example, is for healthcare providers and healthcare clearinghouses and things like that. But if you're doing bankruptcy and part of that bankruptcy is medical insurance, medical premiums or medical bills, you now can be lumped in as a business associate for HIPAA. Now, what does that mean for you? Well, if you're collecting any kind of personally identifying information or any health related information on any of your clients, you need to have things in place to cover your behind, right? How many of you need to get your client's name, their address, their vehicle information, their date of birth, their account numbers? If you're doing estate planning, sometimes you're prepping letters with the account numbers on them. So anytime you're dealing with personally identifying information or HIPAA information, you need to protect it. You have to, under the law, you have to protect it. Now, does that mean that you're always going to be subject to all the things? Well, on the high level, probably not, because you may not be the covered entity or whatever the organization is. But if you are collecting that data and not protecting it, and it gets out or somebody hacks your system, you are now going to be liable. They're going to figure out a way to make you liable. So please, please, please protect yourself. Take stock of what you have. Know what you have. Scale down, as Don said earlier. Scale down. Don't keep a bunch of extra crap you don't need to keep. Lock it. Protect the information you keep. Pitch it when you no longer need it. Shred it. Plan for everything. HIPAA, again, is all that protected info like Medicare information and health insurance information and all of that kind of stuff. So I just want to kind of point that all out to you. All of that's in your packet. So again, I don't have a lot of time to talk about that. Lock your computer, put your information away, lock your office, lock your desk, and put passwords on every single device that you are using. Do not leave anything in your car where somebody can steal it. If you are doing home visits, you need to protect that information. You need to hide it so somebody can't just go, oh, look, there's a file. Let me steal the information from that. We use a firewall for our server. We happen to use WatchGuard. Again, this is just information for you. We use Virtru for our email encryption. It's end-to-end encrypted emails. You can read and respond right from your inbox. You can see who's read your emails, and you can control the email and the attachments and set expiration dates. I love this for my estate planning people because I don't necessarily want them to have drafts forever, right? I send them the drafts for review and I put an expiration date on it so that they can't review it after a certain period of time because we got to get stuff done, right? I don't want them to have it for all eternity. So I set expiration dates and then they come in and the same thing, they might get their documents done and they want an electronic copy of it. So I can send it to them because I have end-to-end encrypted email, but I set an expiration. I don't want it just sitting out there forever, okay? HIPAA compliant fax service, I'm going to just quickly touch on that because again, if you're dealing with anything that might be covered under the HIPAA requirements and you are a business associate or you work with any kind of health companies or anything like that, you need to have HIPAA compliant fax, not just a regular fax machine. You have to have that encrypted system. Again, I am a affiliate for them, so that affiliate link is in your packet as well. Whew, all right, I think that we got through it all. Two more things that came up after I prepped my presentation, and that is succession planning. Not everybody has thought about who the heck's going to take over their business when they die or become incapacitated. So I want you to think about that. Somebody come up with a presentation for that because I would like to attend that. And legal resources for you as a business owner. One of the things that has come up a lot for me recently is the Legal Shield service. Maybe finding an attorney that you can have on retainer or creating a relationship with attorneys that you can touch base with and ask your questions of and just be charged maybe by the hour for that. Whew, okay, let me see. There's some questions maybe. System name. I don't know which system because I was too busy trying to get through data. So if somebody can let me know what that system was, what it was referring to. And then so far delivery food sounds like a plan. Is that something that's nothing related to me? Okay.
No. All right. Well, thank you very much, Carol. Everybody in their hand. That was an awesome presentation. And I thank you everybody for attending today. Bear in mind, this is our first run at this. And so we had a little hiccups, but I think it went very well in the end. But the last word of the day, the verification word is pillow. So I'm going to try to hold it up here in front of there. So there's the last word of the day. And so again, you can respond to one of my previous emails everybody has the email that they got from me yesterday with the instructions on how to access. So please respond to that email and give me the 4 words. And then probably not today, probably tomorrow, I will get out your certificates, but I will get those to you. And going forward, I anticipate that we're going to have a similar type seminar. Right now we're scheduled for April. I may move that back a little bit because we've been, as all of you are probably aware, we've been granted some additional time by the Board of Legal Document Preparers to get our CE credits done. So just in the interest of a kind of setting something past all these critical time periods where the health crisis is kind of increasing, at least in some areas, I may move that back. But for right now, it is set for April, but I don't have a posting right now for a webinar. So don't register right now. I'll send out notices when I have that together. And also going forward, I'm going to do my best. The plan is that even in the live ground seminars that we have, and I like those better because I like to see all your happy, shining faces. And I just think it's important that we all have an opportunity to kind of mingle in the business in person. But hopefully we can get back to that real soon. But even when we do that, I plan on having a webinar as part of that. So you have the option to come in person or just sitting home in your skivvies or whatever and enjoy the seminar or the webinar online. So thank you again, and we'll be signing off now.
I just had two things real quick before we sign off, guys.
Yep.
One is somebody said they needed the last word, so if you want to repeat that one more time.
Sure.
And then I just have one more thing that I wanted to add before everybody logs off.
The last word again, pillow. Okay.
All right. And the last thing that I just wanted to say is, obviously, I don't do every kind of legal document preparation in the world. I've limited myself to certain things. And I can't see you guys, so I can't ask for your business cards and your information. So I have a small offer for you guys. I would love to get to know more CLDPs and learn more about your businesses and what you do, because I think as a community, as a certified legal document preparer community, we need to be helping each other. We need to help each other's businesses, but I can't do that if I don't know what you do. So as an incentive for you guys to connect with me, I would like to encourage you all to mail me your brochure, information card, anything that can help me understand a little bit more about who you are and what you do. Give me the opportunity maybe to meet with you if you're open to that when all this COVID ends. But as an incentive to get those things mailed to me, for every person that mails me something, I'm going to put your card in a drawing. And for every person that sends something in, there's about 50 people today, up to $50 I will give in a gift card of your choice. So if only 10 people send me stuff, it'll be a $10 gift card. But if all 50 send it in, then I'll do a $50 gift card of your choice. I'll pick a card out of the box. And then just know I'll probably reach out to you to see if we can have coffee sometime, because I want to get to know you. I think that's important for us to build our businesses. Thank you guys so much. We appreciate you. Take care.
Bye.
Stay safe and healthy.
Hayden is now exiting.
Janice Reyes.
Is now exiting.
Sandy Bunfill.
Is now exiting.